Item A.
None appears for the appellant on the call. Lays the matter after a week. In the event of subsequent non-representation of the appellant, appropriate orders will follow.
Item 9.
May I please, Lordship? Matter will taken after some time. Senior is another day.
Why?
Senior is another day. After 10 minutes, Lordship.
With the service completed in this matter?
Completed, Lordship. Completed. But wrongly entered in orders.
Mr. Kolita, you were for respondent number?
Respondent number 3.
Respondent number 3.
But respondent number 1 and 2 is strike out already. Only respondent number 3 is there.
Okay. Heard, Mr.
Dr. Arhak.
Learned counsel appearing on behalf of Mr.
Arali.
Learned conducting counsel for the appellant. And also heard Mr. Kolita for the respondent number 3. It is submitted at the bar that service in this matter has been completed. LCR has been received. Received. LCR has not been received. But the LCR has not been received in view of the office note dated 16/2/2026. In view of above, it is provided that recessal is the matter. After 2 weeks, and shall issue urgent reminder to the learned tribunal for transmitting the record.
Lordship, kindly fix the date, Lordship. Kindly fix the date, Lordship.
On 24th July.
24th July.
Item 10. Item 10.
May it pleases your lordship. Lordship, office note dated 1/6/26 says AD card for respondent 2 is awaited. Lordship, after speed post, there is no question of AD card, Lordship. The registry should have given the postal track report. LCR. also.
Mr. Bhattacharya, you were for
I am for the claim in manner. Respondent number 1.
1.
One.
Heard Ms. Mazumdar, learned counsel for the
Why not,
appellant, and Mr. Bhattacharya for the respondent number 1. Office note dated 1/6/2026 indicates that AD card in respect of respondent number 2 is awaited. Then LCR has also not been received. In view of above, it is provided that recessal is the matter after 4 weeks, and issue urgent reminder to the learned tribunal for transmitting the record, and also shall put up one up-to-date office note after tracking the consignment in the website of the department, postal department.
May Tribunal. There is an IA pending 1361 of 26 that may be considered without the presence of the.
Not today, Lordship.
Well,
This-
appeal is admitted way back in 2025. Because this is
I have
filed
been
for
not
stay in
in-
2026. And I am waiting for getting the at least the 50%.
There is no stay, Lordship. They can I haven't even brought my file. I do not have a stay petition with me.
No, this I is not pressed by you.
Till now, it is not pressed. They are open for 147, under 147, Lordship. Because the owner, the respondent number 2 is necessary in the case. And that is why I'm saying about postal track report, Lordship. And it can be, registry has to put only the postal track report, then it can be considered.
Item 11.
Same, Lordship. The office note also is same, 1/6/26, AD card.
This is a receipt. Heard Ms. Mazumdar, learned counsel for the appellant, Mr. Bhattacharya for the respondent number 1. Office note dated
1/6/26.
1/6/2026 indicates that LCR has been received, but the AD card in respect of respondent number 2 is awaited. In view of above, it is provided that recessal track the consignment in the departmental website and put up on up-to-date office note and list the matter after 2 weeks.
Highly obliged, Lordship.
Item 12,
Can I get it? Yes, my-
Take it that one.
22nd, June.
Both the case. Both the cases.
At that 4 weeks, this is.
Item 12,
May it please your lordship.
Mm.
Lordship, as per the Dusty report, service could not be done because respondent number 1 and 2 has sold off their property and shifted to Bongaigaon. So some time may be granted so that we can find a new address of the respondent numbers 1 and 2.
We will be finding Otaratnama for responding.
Or then service is complete, lordship.
Oh, respondent number
1 and 2.
1 and 2.
Then-
2 or 4? 3 and 4.
Then service is
Third,
complete.
Miss Sarkia, learned counsel for the appellant. Miss
lordship.
J. Akhtar, learned counsel for the respondent number 3 and 4. Mr. A. Mishra, learned counsel for the respondent number 1 and 2. 1 and 2. Mr. Mishra submits that he will be filing his power within
By tomorrow.
by tomorrow. He will file his Wakalatnama in this matter. And
LCR
since
is-
service has been completed and LCR has been received, rest is the matter for hearing in usual course.
Obliged, lordship.
item 13,
May I please your lordship, we have to await for service report because I have taken steps on 29/5/26.
Heard Mr. Mandal, learned counsel for the appellant. Office note dated 2/6/2026 indicates that service report in respect of respondent number 1, 2, and 3 are awaited. List the matter after 2 weeks, awaiting service report upon respondent number 1, 2, and 3.
Oblige your lordship.
item 14,
May it please your lordship. Lordship, as per office note dated 2/6/26, lordship, we will have to ascertain the address and also the legal heirs of respondent, lordship.
Heard
Four.
Ms. Mozumdar, learned counsel for the appellant. Mr. Agarwal for the respondent number
1 and 2.
1 and 2. 1 and 2. Office note dated 2/6/2026 indicates that unserved notice issued to the respondent number 3. The notice issued to the respondent number 3 returned unserved with a postal remark that no such address found. And notice issued to the respondent number 4 returned unserved with a report. Addressee died.
5 is served, lordship. Postal tracking of 5.
And in respect of respondent number 5, the said office note indicates that the notice was delivered to the addressee as per postal tracking report. Postal tracking report in view of above. Notice deemed to have been served upon respondent number 5, but respondent number 5 remain unrepresented today. The learned counsel for the appellant shall obtain instruction in respect of respondent number 3
And 4.
and also obtain instruction in respect of the legal heirs of the respondent number 4.
Yes.
List the matter after 2
And-
weeks,
TCR is received. Lordship, 4 weeks.
4
because
weeks.
Highly obliged.
Career distance research.
item 27,
May I please know. In this case, learned counsel has appeared for the respondent number 2, 3, and 4, my lord. My lord, I'm sorry, my lord, I could not check the last office note. With regard to 1, my lord, fresh steps were taken on the last day.
In respect of respondent number 1,
My lord, the,
Mr. Bhatfor, TF, TN4,
yes, please.
respondent number 2.
2, 2 for 2. Okay. Heard Mr. Gupta, learned counsel for the appellant. Mr. Bhatt for the respondent number 2.
And I put 3 and 4.
Your name, please?
S. Sakya.
S. Sakya, learned counsel for the respondent number 3 and 4. Whether you have taken a step upon respondent
Yes,
number
my
1.
lord, on the last occasion, fresh steps
When?
were taken, my lord. On my lord, 10/4/25, my lord.
Okay, office note dated 3/6/2026 indicates that service report in respect of respondent number 1 has been received. And as far as said report, the process server has gone to the office of the addressee, but he found the same closed. And as such, notice could not be served. Accordingly, the said office note also indicates that as per report, the addressee left the address long back and shifted to Gauhati. In view of above, Mr. Gupta, learned counsel for the appellant, shall obtain instruction in respect of the present address of the respondent number 1 and shall take fresh step upon him within a period of 1 week from today by speed post and also by usual process. And recessalize the matter after 4 weeks.
item 28,
May please your lordship, the office note dated 2/6/2026, lordship, at for service report, lordship, I take fresh steps against the respondent number 1, lordship. Takes fresh steps, lordship.
You have taken or you want to take?
Already steps taken,
You
lordship,
have taken.
at for service report, but I,
Heard, Mr.
N. Ahmed.
N. Ahmed, learned counsel for the appellant. Office note dated 2/6/2026 indicates that service report in respect of respondent number 1 is awaited. How many respondents are here?
2.
List the matter after 2 weeks awaiting service report upon respondent number 2. Sorry,
Problem.
1. Respondent number 1.
item 29,
I'm sorry, Lordship, I could not go through the office note, Lordship.
Heard, Ms. Mazumdar, learned counsel for the appellant. Office note dated 7/4/2026. No. 3/6/2026 indicates that LCR has been received. And unserved notice in respect of respondent number 3 returned with a report not found. And no unserved notice in respect of respondent number 1 and 2 has been received.
So registry can put the postal track report, Lordship.
Said office note also indicates that postal journal has been placed at flag mark postal journal, and the same indicates delivery of notice upon respondent number 1 on 10/4/2026 and upon respondent number 2 on 11/4/2026. In view of above, notice deemed to have been served upon respondent number 1 and 2.
3 may be striked out, Lordship. He is a driver.
Ms. Mazumdar, learned counsel for the appellant, submits that the name of respondent number 3 may be struck off from the array of this appeal. Accordingly, taking note of the submission of Ms. Mazumdar, learned counsel for the appellant, the name of respondent number 3. No, it is provided that the name of respondent number 3 be struck out from the array of this appeal at the cost and risks of the appellant. Since the service has been completed and the LCR has been received, rest is the matter for hearing in usual course.
Item 30.
May it pleases your lordship, as per office note dated 3/6/26, unserved notice for respondent 3, a write back with incomplete address, flagged unserved notice. And lordship, postal journal says respondent number 1 received on 11/4/26 and 2 on 10/4/26, and TCR received. So lordship, in this case also, I would pray that the respondent number 3 may be striked out, lordship. Oh, no. No, lordship, he may have the incomplete address. We will try to find out the address, lordship, because the case is of driving license. He's the driver. May not be struck out.
Okay.
Or else we
Ernest
will try
Majumdar,
to
learned
serve him by
counsel for the-
Dusty, lordship. He's from Kamrup only.
Okay.
We may be given an opportunity to serve by Dusty.
Office note dated 3/6/2026 indicates that notice upon respondent number 1 and 2 delivered on 10/4/2026 and 11/4/2026 and 10/4/2026 respectively. And the said office note also indicates that unserved notice issued to the respondent number 3. The notice issued to the respondent number 3 returned unserved with a postal remark incomplete address. Ms. Majumdar submits that she may be allowed to effect service upon respondent number 3 by disseminate. Accordingly, it is provided that Ms. Majumdar shall effect service upon respondent number 3 by disseminate and director file and affidavit in respect of the service before this court. Said office note also indicates that LCR has been received from the learned tribunal. Place the matter after 2 weeks.
No, lordship, Dusty, it will take time.
Of
4 weeks,
4 weeks.
Or 6 weeks.
4 weeks.
Highly obliged.
Item for admission, item number 1 to 5, ordered list.
It's a letter taken after some time. He is appearing issuing legal code number 1, will be taken after some time.
Okay.
Item number 6 and 7.
We'll take up item number 7, my lord, that's CRP. Because notings we have done in the CRP. The facts in a nutshell is that, my lord, the petitioner before lordship filed a suit before the trial court. Now the respondents, they have filed an application under section 8 of the Arbitration and Conciliation Act, saying that there is an arbitration clause. So in that view of the matter.
So the matter was earlier referred to the mediation.
Yes, mediation.
What happened there?
No, mediation, it did not succeed, my lord. Thereafter also, my lord, the respondents took time for trying to settle the matter, my lord, but no positive response came out, my lord.
My lord, the matter relates to non-payment of certain running fees, my lord. Not that the retail fees are not paid, my lord. So regarding.
No, my lord, they running bills, my lord, petitioner is the contractor. They have dispossessed of, they has taken the possession. They have, my lord, taken all my materials. So aggrieved by that, my lord, non-payment of bills and damages compensation suit was filed. Now they say that they filed an application under section 8. Now an order was passed at lot, she will find it 135, that is under challenge. At page 135, my lord.
Because out of 15 crores, my lord, 12 crores has already been paid, my lord. regarding the balance amount, some dispute arises between the parties regarding the deviation from the terms of the contract, standard of the work.
This matter has to be has to be dealt with in the suit. Now, in this case, my lord, the lordship, my lord, we have to satisfy because they have taken a ground that clause 23, 24, and 25 of the agreement, there is an arbitration clause. Now, my respectful submission is that, my lord, if we go by this clause, my lord, it does not constitute an arbitration clause. Therefore, the suit is maintainable. Now, trial court has said, my lord, that since there is an constitute this clause to be an arbitration clause, and said that plaintiff is returned, my lord. So therefore, because one is, my lord, CRP and one is FAO. Now plaintiff is returned, then, my lord, an appeal will lie. So that is why, my lord, two things. If your lordship kindly come to page operative portion, my lord, page 149, my lord. It starts from 135 and 149, my lord. Oh, it will. As discussed above, there is no dispute to the fact that there is an agreement between the parties and that the agreement, the provision of referring the matter to arbitration in case of any dispute is also incorporated. Therefore, in view of the discussions made above, this court does not have any option but to refer the matter to arbitration. The parties are directed to appear before the appropriate forum for resolve of their dispute. The plaintiff is returned to the plaintiff under Order 7, Rule 10 of CPC for presenting it before the appropriate forum. Now, my lord, we are aggrieved by this order. Because if your lordship kindly comes to their section 8 application, my lord.
Page number?
Page number 93, my lord. Lordship got it, my lord. Page 93. Page number 93, this is in section 8 application. And the operative portion, your lordship will find it page 96, para 5. Para 5, madam. The defendant begs to state that section so and so conditions of contract and contract forms stipulates the general condition of contract, and under the said general conditions of contract, there are clauses being clause number 23, 24, and 25, which are relevant and relied by the defendants while preferring this instant application under section 8, read with section 5 of the Arbitration Conciliation Act and also Order 7, Rule 10 of the CPC. Now, my lord, what is this 23, 24, and 25? The lordship will kindly come to the conditions of contract. Lord.
No, Mr. Das, admittedly, there is a clause of arbitration in the
No, my
agreement.
lord. There is an, my lord, there is an, if your lordship will kindly come to my lord, because these say they may. But Supreme Court has, my lord, time and again says that when it is may, then, my lord, it does not constitute an arbitration clause. It says that the parties may. That means it depends whether the party may decide or decide. It does not statutorily say that it will be an arbitration clause.
You produce the relevant decision of the Supreme Court.
Yes, I am
also?
producing. But before that, I'll just draw your lordship attention to this clauses 23, 24, and 25, page 109, my lord. Page 109, my lord.
Yes.
So what it is down below, dispute settlement. The employer and the contractor shall attempt to settle amicably by direct negotiation.
Clause, you were reading clause number?
23, my lord.
Pardon?
23. Second from down below, my lord. Dispute settlement. Page 109. Left
No,
hand
it
side.
is not in 109. 23 is in page number 110.
My lord, maybe.
Yes.
Yes.
Dispute settlement.
Dispute settlement. The employer and the contractor shall attempt to settle amicably by direct negotiation any disagreement or dispute arising between them under or in connection with the contract. Any dispute between the parties as to matters arising pursuant to this contract, which cannot be settled amicably within 30 days after received by one party or other party's request for such amicable settlement, may, my lord, this is
Hmm.
important, my lord. Lordship will kindly note down.
Hmm.
May be referred to adjudicator or dispute resolution committee by either party as specified in so and so within 15 days. Then 24, my lord. Next clause. This appointment of adjudicator. Then your procedure for dispute resolution, my lord.
Hmm.
25. 25.2, my lord. I'll refer your lordship 25.2, my lord. Either party may, lordship, what in my lord? 25.2. Either party may refer a decision of the adjudicator or DRC to an arbitrator within 30 days of the adjudicator's or DRC's written decision. If either party refers the dispute to arbitration within the above 30 days, the adjudicator or the DRC decision shall be binding. Then 25.4. In case of arbitration, the arbitrator shall be conducted. Now, my lord, 23 says that dispute resolution, it is may. And 25, my lord, if the parties refers the dispute to the dispute resolution. So, my lord, this 23, 24, and 25, if we read this, my lord, it does not say the parties shall refer the dispute to arbitration, my lord. Now, I don't want to citation. Now, these are the judgments, my lord, of the apex court, my lord. First, I'm relying on this 26 INSC 384. Relevant para is para 12, my lord. Page 8, my lord, of this one. Page 8. Para 12. Having taken due note of the interpretation of the word can, as well as well-settled principles of contractual interpretations, we now have to consider whether clause 25 actually constitutes an arbitration clause. So and so spelled out the requirements of such clause in the following terms. Among the attributes which must be present for an agreement to be considered an arbitration agreement are: the arbitration agreement must contemplate that the decision of the tribunal will be binding on the parties, that the jurisdiction of the tribunal, I'll skip this and I'll come to the middle portion, my lord. It's underlined. Ravindra J, writing for the court, everybody, had held that the words used in the agreement should disclose a determination and obligation to go for arbitration and not only provide for the possibility of going to arbitration. When the word provides only a possibility, the same does not constitute a valid arbitration agreement. So, my lord, here lordship has seen in 23, it says that may.
No, whether the word may and shall is interpreted here in
Yes,
this judgment.
yes, my lord, it will.
Where?
Yes. Because page 5, lordship will come, my lord. Since the judgment impugned before was an application for appointment of an arbitrator, it is apposite to refer to the duty cast upon the court in deciding such an application. The main dispute before us swings on interpretation of the word can. As ordinarily understood, it means capacity, capability, or factual possibility. The Oxford Learner's Dictionary discusses the word can as a word that is used to say that it is possible for someone or something to do something or for something to happen. Similarly, Merriam so-and-so, Webster so-and-so. Lastly, we may refer to the Britannica Dictionary. It defines the word as follows: to be able to do something, to know how to do something, to have the power or skill to do. So-and-so, so-and-so. Having understood the meaning of the word, it may be observed that its use in judicial interpretive context is limited. Most often the word may or shall are used. Normally, the former denote discretion but not compulsion to act, but then it shall be contextual. Put differently, the authority is permitted to do something, but it is not required to. If it is the requirement that it is to be denoted, shall is most appropriate word which signals a mandate or obligation. So in this case also, my lord, it says that, my lord, if it is not in strict terms, my lord, then it can be it should not be constituted as a valid arbitration agreement. Then, my lord, next page, para 11, my lord, page 11, my lord. So in the first judgment, my lord, it is says that can. What is the meaning of can? The second judgment, my lord, page 11, paragraph 30 and 31. Page number 23, my lord, para 30.
Yes.
Argument of the learned counsel for the appellant is that clause 13 provides option to the parties, which includes any one of the parties to seek dispute resolution through arbitration, and therefore it is nothing but an arbitration clause. According to him, the use of the word may in clause 13 does not provide choice to the parties to agree or not to agree for arbitration. Rather, it is a choice given to either of the parties to seek a settlement through arbitration, and therefore when one party exercises the option, the other party cannot resile from the agreement. In that sense, according to him, clause 13 is an arbitration agreement. 31. We do not agree with the aforesaid submission because clause 13 does not bind parties to use arbitration for settlement of the disputes. Use of the words may be sought imply that there is no subsisting agreement between the parties and that they or any one of them would have to seek settlement of dispute through arbitration. It is just as enabling cause whereunder if parties agree, they could resolve their dispute through arbitration. In our view, the phraseology of clause 13 is not indicative of a binding agreement that any one of the parties on its own could seek redressal of interstate disputes through arbitration. We are therefore of the considered view that the High Court was justified in holding that clause 13 does not constitute an arbitration agreement. This is 25 judgment. In this case also, Honorable Apex Court has held that if there is may, my lord, it does not constitute an arbitration clause because it is for the parties whether to go for an arbitration or not. Then, my lord, page 26, my lord. In this case also, my lord, what is the meaning of may that has been interpreted at para 22, my lord? Okay. Page 35. Also got it, my lord? Page 35. It is contended for the petitioner that the word may in clause 5 has to be construed as a shall. According to the petitioner's counsel, there is true intention of the parties. The question then is as to what is the intention of the parties. The parties, in my view, use the words may not without reason. If one looks at the facts of clause 4 precedes clause 5, one can see that under clause 5, parties desire that in case of dispute, the civil court at Bombay are to be approached by way of a suit. Then follows clause 5 with the words, it is also agreed that the dispute may be referred to arbitration, implying that parties need not necessarily go to civil court by way of suit, but can also go for arbitration. Thus, clause 5 is merely an enabling provision as contended by the respondents. I may also state that in case where there is a sole arbitration clause couched in mandatory language, it is not preceded by a clause like clause 4, which discloses a general intention of the parties to go before a civil court by way of a suit. Thus, reading of clause 4 and 5 together, I am of the view that it is not the intention of the parties that arbitration is to be the sole remedy. It appears that parties agreed that they can also go for arbitration also in case the aggrieved party does not wish to go to civil court by way of a suit. But in that event, obviously, fresh consent to go to arbitration is necessary. Further, in the present case, in my view, must be deemed to have been used the may and shall at different places after due deliberation. So in this case also, my lord, the apex court has held that when further intention is required, my lord, it cannot be constituted as a arbitration agreement. And my lord, another judgment of the Supreme Court at page 37, my lord. The relevant paragraph 17, it's marked, my lord. Paragraph 17, page 47. The above, what you got in on page 47, para 17. The above ruling lead us to the irresistible conclusion that mere use of the word arbitration in a clause in an agreement is not clinching or decisive. Section 7 presupposes an express intention of the dispute or difference being resolved through arbitration, and mere reference to the terms is not sufficient to meet this threshold. The Arbitration and Conciliation Act acknowledges the existence of an arbitration agreement based on its substance rather than its form. Then she will come to para 19. Clause 8.28 of the arbitrations of the agreement states that the parties must first attempt to negotiate the dispute in good faith. In this case also, Lordship has seen in clause 23, it says that parties must try to settle it amicably. If there is no amicable settlement, then they may go for arbitration. This part of the clause is admittedly not disputed in its meeting. The next part of the clause specifies that if the negotiation fails, then the parties would be obligated to mediate the stated procedure and is then followed by the punctuation colon, following which it prescribes that any dispute arising out of or relating to any way to the agreement shall be resolved by arbitration through senior management comprising respective chairman of the two parties arbitrated. Moreover, the agreement further stipulates that should the dispute not be resolved within 15 days after the proposed arbitration, the complaining party shall seek remedies through courts of law. Then para 21. Is mere repetition of the word arbitration clinching decisive? It is now time to ascertain in line with the aforesaid decisions whether the party's intention was indeed to arbitrate or merely to delineate a structured process of mediation. Then, my lord, finding is, my lord, para 27, page 51. Lord, various judgments has been discussed, and after discussing, the finding is, in our view, clause 8.28 of the agreement does not evince an intention to refer dispute to arbitration for the above mentioned reason. So it says that this is not a valid arbitration clause, my lord. Then, my lord, another the page 55, my lord.
Not necessary to
So
go through
all these judgments, my lord, law is very well settled, my lord, that in order to constitute an arbitration clause, my lord, there has to be a positive meeting of mind of the parties. That parties should agree that yes, in case of any dispute, the matter will be resolved, will be referred to arbitration. But here is a clause, my lord, which says that the parties will first try to negotiate. If their negotiation fails, they may refer to arbitration, then an arbitrator may be appointed. So my respectful submission is, my lord, that the clause 23 and 24, 25 does not constitute an arbitration agreement. So therefore, the impugn order whereby the learned trial court has held that there is an arbitration clause and the matter has to be arbitrated is an perverse finding. And that apart, my lord, then order, let us assume that yes, there is an arbitration agreement. The finding that return of plaint, my lord, when the court comes to a finding that yes, there is an section 8, when under section 8 that there is an arbitration agreement, the court will direct the parties to approach before the arbitrator, my lord. Where is the question of returning the plaint? Because before the arbitration, my lord, the plaint is not filed. When the plaint will be returned, it will be filed before another court. But before the arbitration, my lord, it will be a statement of claim. So the finding of the trial court that the plaint is returned, my lord, that is also not sustainable in the eyes of the law. So in that view of the matter, my humble submission is that the impugn order should be set aside, my lord, and the should be directed to proceed, my lord. Just a second. But one more, the last judgment, my lord, it clearly says at page 66, para my lord 7. I'll just point out this one. Page 72, my lord. It's a, I have highlighted, my lord. It says that where, my lord, fresh consent is required, my lord, between the parties for referring the matter to arbitration, that does not constitute an arbitration clause, my lord. As held by the Supreme Court in so and so, so and so, so if the agreement between the parties requires or contemplates a fresh or further consent for reference to arbitration, it would not constitute an arbitration agreement.
Okay, yes.
But I have to respond the judgment, my lord, because I don't have the citation.
Hmm.
For that, my lord. Please refer to page number 125 of your PRP.
No, you first come to this FAO.
FAO, my lord.
Yes.
Page 126, my lord, of the FAO.
126. Yes.
Because they did not raise these grounds in the trial court, my lord. Page number 126 is their objection of my application under section 8 of the Arbitration Act, my lord. And relevant para is para 13, lord. Page number 133. This is their objection in the trial court.
Relevant paragraph.
Paragraph 13, page number 133.
Yes.
May I read, my lord?
Hmm.
That above made in para number 6 are also all matters of record, and record will speak the truth. There is no such dispute requires to be referred to the arbitrator for conciliation in case the defendant opposite party paid the unpaid bill amount due to the plaintiff as per construction work and bill submitted by the petitioner plaintiff. That as soon as defendant opposite party paid the amount due to the plaintiff, there is nothing to be continued the suit. That, this is important, my lord, that in case any dispute arising out between the parties which cannot be settled by the civil court, then same may be referred to the arbitrator. But in the present suit, matter is simple. The work done by the petitioner plaintiff for which plaintiff submitted bill, it is a dues due to the plaintiff by the defendant. In case anything about the claim amount claimed by the plaintiff in the claim, the defendant opposite party should first deny the same by filing written statement. Before filing written statement, there is no reason to refer the matter to the arbitrator as prayed by the defendant. It is premature prayer before the court unless the defendant disputed the amount claimed by the plaintiff is denied by the defendant by filing written statement. The rest of the advertisements made in para number 6 are denied by this objector plaintiff. So their objection is that, my lord, first the dispute may refer to the civil court, my lord. If civil court fails, then matter may be referred to the arbitrator. And second objection is that before the trial court, we should file first the written statement. Then the matter may be referred to the arbitrator, my lord. But they did not raise these grounds before the trial court, my lord, that the agreement, the arbitration clause do not constitute, my lord. And secondly, my lord, the dispute settlement mechanism, my lord, this is case number 110 of their FAO, my lord.
One.
110, my lord. 110. This
Page,
is
page number
110 in the FAO.
110. Yes.
My lord. My lord, these are the general conditions on contract, my lord.
Mm.
It includes in the contract agreement, my lord. And the first one is 23, my lord, dispute settlement. The employer and the contractor shall attempt to settle amicably by direct negotiation any disagreement or dispute arising between them under or in connection with the contract. 23.2, my lord. Any dispute between the parties as to matters arising pursuant to this contract which cannot be settled amicably within 30 days after received by one party of the other party's request for such amicable settlement may be referred to the adjudicator or dispute resolution committee by either party as specified in the SEC within 15 days after the expiration of amicable settlement period, my lord. Then 24. The adjudicator shall be as specified in the SCT if identified and agreed by the employer and the contractor during the contract agreement. If not identified in the SCT, the adjudicator shall have to be agreed and appointed whenever the dispute arises. By the consensus of the employer and the contractor, if the parties cannot reach an agreement on the appointment of the adjudicator, either party may request the appointing authority designated in the SCT to appoint the adjudicator within 15 days of receipt of such request. Then 24.2. Should the adjudicator resign or die is not relevant, my lord. 24.3. The DRC shall comprise of 3 members. Each party shall appoint 1 member each, and the third member who shall act as the chairman shall be appointed by the 2 members appointed by the parties. If either party fails to nominate a member of DRC within this, then the appointing authority designated in the SCC shall, upon the request of either or both the parties, and after due consultation with both parties, appoints these members of the DRC. 24.4, this is not important, my lord. Then 25, my lord. Procedure for dispute. If a dispute is referred to the adjudicator or the DRC, then the adjudicator or the DRC shall give a decision in writing within 30 days of receipt of a reference of the dispute. Either party may refer a decision of the adjudicator or DRC to an arbitrator within 30 days of the adjudicator's or DRC's written decision. If either party refers the dispute to arbitration within the above 30 days, the adjudicators or the DRC decision shall be final and binding. 25.3, my lord. The adjudicator or the DRC member shall be paid by the award's payment, my lord. So, my lord, these 3 clauses, these are the dispute resolution mechanism, my lord. It is a multi-tier process.
Hmm.
And the question is, my lord, whether the applicant approached this adjudicator or the DRC or not, my lord. Because he did not approach this forum, my lord, and he directly filed a suit before the civil court, my lord. So once he bypasses the pre-arbitration steps, so he cannot use that bypass as a ground to resist the arbitration clause, my lord. And regarding my learned friend has said that may or can, my lord, I have to respond because I do not have the citation, the Supreme Court, my lord. But my humble submission is that these clauses, it is effectively constitute an arbitration clause, my lord. And
No,
clauses, my lord.
the contention of Mr. Das is that the word may is there in the agreement.
Yes, my lord.
So the parties are not bound to go for this arbitration in view of the decisions relied upon by him.
Yes, I have to respond, my lord, because I do not have the citation, my lord.
Okay, Mr. Das, you give the citation to him. Can you respond today?
Not today, my lord, today not possible. Any day in this week, my lord.
Let it be tomorrow, man. Let him go through it. Well, then you'll,
Monday?
it will be fresh in Lordship's mind also, man.
For example. Monday. Heard Mr. Edas, learned counsel for the appellant. In CRP, you are for the respondent.
No, me both my lord petitioner. CRP and FAO both, I am for the petitioner.
And-
FAO we have filed because your lordship has seen that return of plaint. If it is a return of plaint, this is an appealable order. So that is why FAO. And section 8 application is revisable.
In both the petition, you have challenged the same order.
Same order. Yes,
Uh, in FAO and also in CRPIO. And Mr. Your name, please?
S. Borwa.
S.
M. Borwa.
S.M. Borwa, learned counsel for the respondent. Argument of Mr. Das since completed, but Mr. Borwa submits that he may be granted some time so as to enable him to go through the decisions relied upon by Mr. Das, learned counsel for the appellant. Mr. Petitioner. Fair allowed, rest shall list the matter on Monday. Mr. Das shall furnish a list of the citation referred by him to Mr. Borwa during the course of the day.
Yes. Let it be parted, my lord, otherwise again. Part
Rest shall list the matter as parted.
Items on the hearing column. Section number 31 and 32 upgraded.
Please, ma'am. But this is that same matter, my lord, which I had mentioned. The impugned judgment. Sir, no, final. But this is that same matter, my lord, which I mentioned day before, my lord.
Yes, yes.
And the impugned judgment has created a matter, some kind of a stalemate between the plaintiff and the defendant. And matter left that matter the place, the suit property, my lord, in a condition called in medio. Neither the court, his suit for specific performance has been dismissed. And my counterclaim, even though all the facts are admitted that I am the rightful owner, is also rejected. And the court ultimately gives a matter finding that I don't have a right title over the said property. And goes on further to say, my lord, a further finding that the counterclaim is partly allowed. So, my lord, neither I get the possession back, nor he is relieved of the possession which he got by virtue of an ex parte stay. And then, my lord, virtually the effect is from 2013, he is enjoying as a rank stranger over the said property and collecting rent to the utter dismay, my lord. And we, my lord, kept on filing application after application for appointment of a court receiver before the trial court. And all were, my lord, somehow disposed of on the ground that we will hear the matter finally. And before this honorable court, my lord, that is the reason stay was not granted. And the matter was heard, part heard, almost judgment reserved, my lord, for 3 times consecutively from 2019 onward. And now we are before my lords. Kindly have, I'll just take my lords to his, what is the suit? If my lords may kindly have the suit in RFA 73, my lord, we had filed the IA for bringing on suit on record. IA 2813.
TCR is the entire.
If my otherwise the entire record is here. The record was summoned.
Yes.
If my lords may kindly have this IA 2813, the true copy of the specific performance suit, page 6. Annexure 1.
Yes.
The title is my suit for specific performance of contract dated 10th of October 2013. Confirmation of possession and for permanent injunction. Valued at 1 crore of rupee. The defendant is the absolute owner and possessor of a plot of land measuring 1 kattha, 17 lechas, covered by DAG number so and so of Revenue Village Khanapara under Mauza Beltota in the district of Kamrup, Assam, and upon the aforesaid plot of land, the defendant has constructed an uncompleted G+3 storied RCC building situated by the side of Ganesh Mandir, High School by lane, 6 Mile Khanapara, with due permission from the concerned authority. Two things are very clear, my lord, that I am the owner and I had also sought the permission of the concerned authorities. Then my lords may kindly have para 5. I would not take my lords through the entire plaint. That as aforesaid, the plaintiff noticed that the defendant not at all ready or make any attempt to obtain such sale permission from the authorities, authorities, the reason best known to him. Then para 6, that the plaintiff further begs to say that he was under the impression that the defendant might have already applied for sale permission before the authorities. But when the plaintiff, despite his best effort, failed to receive any information regarding the progress of sale permission from the defendant, went to the office of the Deputy Commissioner Kamrup, so and so authority, to inquire the matter, and found that the defendant has not applied any sale permission to sell the suit property in favor of the plaintiff. Then my lords may kindly have his prayers. Prayer A is specific performance. Prayer B is for decree of execution of the sale deed by this honorable court in favor of the plaintiff in case of failure on the part of the defendant to execute the final sale deed in respect of the suit property more fully described in the schedule to this plaint. C, a decree for recovery of 90 lakh with normal bank interest rate from the defendant if for any reason the sale deed cannot be executed. D is important, my lord. A decree for confirmation of possession of the suit property which is more fully described in the schedule to this plaint in favor of the plaint. A decree of permanent injunction restraining the defendant, his men, agents, servants from entering upon the suit property and also restraining him from disturbing the peaceful possession of the plaintiff over the suit. Then he also files an application under 13 and 1 and 2, my lord. And that is also very important because in 13 and 1 and 2 also he reiterates the same thing, and the court, my lord, but I had prepared a list of dates and events also. I'll give it to my friend as well, court master. But this is why important is because these orders are also very important because I am ultimately seeking also a restitution of the property. But after a suit, kindly have the third page, Mano. The date is 16th of June 2014, page 3. The learned court granted ex parte status quo. Order in miscellaneous J case number 237 of 2015. We filed a malord written statement cum counterclaim along with our objection to this application under 13 1 and 2. However, on 5th of November 2014, in a FIR filed by him, we also got a pre-arrest bail. 27/11/2014, my lord. If my lords may, in the meantime, kindly have my written statement. We filed a written statement that is at page. My lord may kindly have the from the annexure 3 in RFA 111, my lord. I'm so sorry, my lord. I'm taking my lords. I should have prepared a convenience note. RFA is 111. at page 31, my lord. Sorry, this is the counter claim. No. I'm so sorry, my lord.
Page number?
Ma, this is I'm so sorry, my lord. I beg to apologize, my lord. Something is. No, this is not the counterclaim. This is a reply to the counterclaim. My lord, may from the TC only, my lord, find. From the TCR file A, my lord. File A. This would be page 58.
Yes.
Now my written statement is there. Para 8. That with regard to the statement made in paragraph 1 of the plaint, the answering defendants admit that the defendant is the absolute owner and possessor of the plot measuring so and so. Then kindly have para 21 at page 38. Sorry, this would be para 21. At page 64, my lord. That the real facts of the case are that the defendant is a owner, pattadar and possessor of a plot of land measuring 1 kattha 17 lechas covered by DAG number so and so.
Which paragraph you were reading?
Para 21, my lords. At page 64
Okay.
of this file A. That the real facts of the case are that the defendant is the owner, pattadar and possessor of plot of land measuring 1 kattha 17 lechas, which is more specifically described in scheduled property mentioned below of this written statement come counterclaim. That the defendant begs to state that the defendant counterclaimant purchased the above mentioned land on 5th of March 2012 by paying an amount of rupees so and so from one Shri Upendra Chaudhary so and so, who was the original owner of land, by executing a sale deed being sale deed number so and so registered at the office of the senior sub registrar. Thereafter the defendant has been enjoying peaceful possession over the scheduled property without any hindrance. To this, my lord, and kindly have my prayers also at page, because that's where, my lord, the whole case falters. Prayer B. A decree declaring right, title, interest of the defendant over the property mentioned in the schedule below. And prayer D. A decree for recovery of khas possession of the scheduled property mentioned in the schedule below by evicting the plaintiff, his men, workers, servants, agents, employees, etc. To this, he finds a counter, and that is at page 71. The plaintiff files a written statement against the counterclaim filed by the defendant. Now, turn to, my lord, paras 4 at page 72, top of the page. That as to the statements made in para 21, 22 and 23 of the counterclaim, the plaintiff begs to state that those are matter of record. My lords may only mark this much. And then para 7, middle of the, or fifth line from the top, my lord, of para 7, the defendant had handed over possession of the suit premises to the plaintiff, and that the same was clearly enumerated in the aforesaid agreement dated 10th of October 2013. Now, my lords, may kindly see the exhibit 1, that is this so-called document, my lord. There is exhibit one, my lord. Where are the exhibit? That is at page 101, my lord, in the same file C1,
Page number?
page number 101, my lord. Of file C1. This is the agreement for sale dated 10th of October 2013 at Gauhati. Chandra Mohan Jha and Alok Ghosh, that is a plaintiff here. And the third covenant is important. Whereas the present seller is the absolute owner and possessor of a plot of land measuring 1 kattha and so and so. Then to my lord buttress this, he files 3 number of receipts, money receipts, starting from page 98. My lords may only mark the date and the amount. The first at page 98 is dated 8th of September 2013 for 30 lakh. Next is 29th of September is again 30 lakh. They are exhibit 1, 2 and exhibit 2, 1, 2 and 3. And then the last is the page 100, 10th of October 2013, 30 lakh again. On the day when the alleged agreement to sale is executed. Now, two things are very much clear, that there is a clear admission on the part of the plaintiff that I am the owner, and the specific performance matter suit for that sine qua non is that there have to be two parties, the owner and the buyer. Now kindly have, my lord, I am only aggrieved to what is the findings recorded by the trial court. Kindly have the impugned judgment now. Dated 12th of June 2019 in RFA number, in both the RFAs, my lord, it is the same. Page 14, annexure 1. At page 15, my lord, the trial court categorically records in para 1, this is a suit for specific performance of a contract, confirmation of possession, permanent injunction, etc. The plaintiff's case in brief is that the defendant is the absolute owner and possessor of land measuring 1 kattha covered by DAG number so and so area, and the defendant constructed an uncompleted G+3 storied RCC building, which is the suit scheduled property. That in the month of September 2013, the defendant approached, my lord, may kindly mark this, it will come in his appeal only. The date, September 2013, the defendant approached the plaintiff with a request to sell the suit property, and on 10th of October, the plaintiff and the defendant entered into an agreement for sale of the price of the suit land was fixed at 1 crore, and the defendant accepted advanced amount of rupees 90 lakh from the plaintiff on the date of execution of the agreement for sale and handed over the possession of the suit property to the plaintiff. That as per the agreement, the defendant was to take necessary sale permission for executing the sale deed. But the defendant on various pretexts avoided to obtain sale permission, and that on 6th of January 2014, the defendant assured the plaintiff that the sale permission would be obtained shortly and sale deed would be executed. But the defendant again did not make any attempts to obtain the sale permission. And when the plaintiff approached the office of the Deputy Commissioner, Kamrup, he found that the defendant has not applied for any sale permission. Then para 3, my lord, we filed our written submission and we again reiterate that we had purchased this property from one Shri Upendra Chaudhary through a registered sale deed. And then issues are framed, my lord, on my counterclaim, issue number 10 at page 17. Whether issue number 9 is whether the counterclaim is maintainable, whether the defendant counterclaimant is entitled to the decree and of relief as prayed for. And it is answered. If my lords may kindly see the issue number 4 also, the operative portion, page 19, because his deposition is so recorded. Para 11. PW1, the plaintiff in his affidavit evidence deposed that the defendant is the absolute owner and possessor of land measuring 1 kattha so and so of revenue village under so and so in the district of Kamrup, and the defendant constructed and uncompleted. And then the possession is handed over to him by the defendant. And the permission was also for the construction, permission from the Deputy Commissioner was also sought by the defendant himself. Then at page 17, page number 23, issue number 10.
Yes.
Somehow the issue number 9 is not there, but issue number 10, which is more, I am more aggrieved of. This issue is whether defendant counterclaimant is entitled to the decreed defendant or as relief prayed for. The counterclaimant defendant as DW1 deposed that he is the owner of land measuring so and so of so and so village in the district of Kamrup, deposed that he purchased the same land on 5th of March 2012 from one Upendra Chaudhary by paying an amount of so and so, who was the original owner of the land, sold in land to him by executing a sale deed number so and so. The defendant counterclaimant did not exhibit the sale deed number so and so or any other land document of copy of Jamabandi to show his title over the said plot of land. In the absence of any evidence to show that the defendant counterclaimant is the owner of the scheduled land, it cannot be said that he is any right, title and interest over the same, and as such the right, title and interest of the defendant over the scheduled property cannot be declared. However, as issue number 4 and 5 are decided against the plaintiff, it is clear that the sale agreement dated 10th of October 2013 between the plaintiff and the defendant is forged, manufactured, void, collusive and inoperative and not binding upon the defendant. Issue number 10 is decided partly in the affirmative. Issue number 11, the issue is whether other relief or reliefs parties are entitled to. In view of the discussions made above, the plaintiff is not entitled to any relief of the present suit, whereas the defendant is entitled to get part decree in the counterclaim. The issue is decided accordingly. Para 23. The counterclaim is partly decreed and it is declared that the sale agreement dated 10th of October is void and inoperative and not binding upon the defendant. Prepare decree sheet accordingly. Now, my lord, the vacuum which has been created is that I am also left high and dry. Now, the issue here also before my lords is also this, that my appeal is prior. I am the owner. In his appeal, my lord, his specific performance is denied on 2 counts. One, he has failed, my lord, to discharge any burden that anything, my lord, to prove the document itself. And secondly, the money which he alleged on the basis of those 3 money receipts are also held to be forged. And that is on account that in the FIR filed by him against me, he had filed, my lords, some other receipts, money receipts. Now that the court took a judicial notice on account that this honorable court in a revision application petition filed by the appellant herein directed that the court may take a judicial notice of the certified copies of those criminal cases pending against the appellant herein. And that judicial notice is ultimately taken in para 18 at page 22. On perusal of Exhibit A, it is seen that the two numbers of money receipts were enclosed and taken judicial notice of the certified copy of two money receipts which are in the case record. It is seen that the money receipts are dated 21st of March 2013, 12th of August 2013 and 21st of March 2013, and in the money receipt Pritam Hazarika and defendant number 2 signed as witness number 1. In his cross-examination, PW2 deposed that he heard that the defendant issued money receipt, but he is silent that he had put his signature as witness in this money receipt. Moreover, the certified copy of the money receipts reveals that those are money receipts dated 12th of January and 21st of March, whereas as per the deposition of PW1, the agreement for sale was executed on 10th of October. So considering the above, it appears that the plaintiff failed to show that there was any money transaction. Now kindly see the fraud committed by the defendant, the plaintiff herein. Kindly, court master. I'll give a copy to my friend also here. Court copy nahi hai? Just see those money receipts. Page 1 is that money receipt of 15 lakh. Of 12th of January 2013. Now kindly see that it is witnessed also by Pritam Hazarika, and Pritam Hazarika is also PW2. Bipul Singh is not examined. And then there is a non-judicial stamp also. The next page is money receipt of 21st of March 2013, again witnessed by these two witnesses, and money receipt is of 45 lakh. Now they constitute 60 lakh in all. Then comes the real, what he files is at page 3, which I had also read from 98, 99 and 100 page. These are totally different money receipts of different time. Because in his deposition, my lord, in his cross-examination, he categorically admits that he never knew the appellant here or the defendant prior to September 2013, and he has first time met him in the premises of the suit property on the day when the agreement to sell is executed, that is on 10th of October. So that is the reason why the court took a judicial fact notice on the there was this order by the High Court. That order was passed by this honorable court, my lord, in RF, in CRP. Kindly have my list of dates also, and this order is in file C2. My lords, may kindly have page 76, 77 of file C2. This page is 76. Otherwise, the trial court had also given us the same relief. That was never challenged by the other side for bringing on record these certified copies. This revision petition is directed against the order dated 10th of October 2018, passed in Miss Case 726, arising out of so and so, and had rejected the application filed by the petitioner defendant under order 18, Rule 17 and 17A read with section for a prayer to recall and re-examine the witness DW1 for the purpose of placing on record the 3 additional documents mentioned in the application. The learner trial court by the impugned order dated had rejected the said application inter alia, holding that the provisions of order 18, Rule 17 is not available for the purpose of recalling a witness in the manner sought by the petitioner. However, liberty was granted to the petitioner defendant to produce the certified copies of the money receipts dated 21st of March 2013, 12th of January 2013, along with the azhar lodged on 15th of May 2014 at the time of hearing of the arguments in the case, so as to enable the court to take judicial notice of their contents and decide the suit accordingly. Mr. Singh submit that although liberty has been granted to the petitioner by the learned trial court to produce the certified copy, yet in view of the observation made in the impugned order to the effect that the petitioner has failed to produce the certified copies at the stage of pressing the application under order Rule 18(7), Rule 17, the same may come in the way of producing the said document at a subsequent stage. From a minute scrutiny of the order dated so and so, I find that the learned trial judge was of the view that after the closure of the evidence, the defendants could not be permitted to recall the witness for re-examination on the ground of introducing fresh documents. In my considered opinion, the view expressed by the learned trial court does not suffer from any infirmity warranting interference by this court in the facts and circumstances of the case. As regards the apprehension expressed by the petitioner's counsel regarding the observation made in the order, it must be noted herein that the petitioner does not dispute the fact that documents sought to be introduced are all part of court of judicial proceeding and therefore would come in within the description of public document within the meaning of section 74 of the Indian Evidence Act. If that be so, there can hardly be any doubt about the fact that certified copies of those documents can be produced before the court, and judicial notice in respect therefore can also be taken by the court subject to fulfillment of the requirement of the provisions of the Evidence Act. Since the learner trial court has already granted liberty to the petitioner to produce the same, those documents and dispose of the revision petition by affirming the order with a clarification that the observations made in the impugned order shall not come in the way of the petitioner to produce the certified copies of the documents in accordance with the provisions of law. In accordance thereto, we filed an application dated 28th of November 2018, file C2, Malad, at page 72. And this order was also part of that application. We also filed, my lord, there was this FIR filed by the plaintiff against the appellant defendant, and that was ultimately dismissed at page 79. Informant absent, seen service report, which goes on to show that despite service of summons, informant did not turn up. As it transpires that information is not willing to proceed with the case on perusal of CD and also on hearing learned additional PPFR stand accepted. Then my lords may kindly have page, the FIR is there. In the FIR also he says the same thing, page 86. This is also the certified copy produced before the trial court. In here also he says that I am the owner. Third line from the top, sorry, second line from the, I have entered into an agreement with Chandra Mohan Jha, son of so and so, in regards to a plot of land measuring 1 Kattha 17 Lecha, so and so, along with G+3 story on the aforesaid plot of land situated by the side of Ganesh Gudi, YD notary registration number so and so, dated at the time of execution of this deed of agreement dated, Chandramohan Jha also gave the sale deed. Now kindly mark this sale deed, my lord, which the trial court says I did not produce. Sale deed of agreement dated Chandramohan Jha number 1930 of 2012, dated 5th of March, wherefrom Chandramohan Jha purchased the said land from Upendra Chaudhary. At the time of execution of this sale, we have also paid. And then enclosures are at page 87, my lord. Copy of power of attorney. This is also not produced along with the suit nor mentioned by him. 2 deed of agreement, 2 number of money receipts. 1 number of money receipt is with our counsel. And those money receipts, my lord, I have just shown, my lords. First is the agreement to sell, which I have already read, page 89 to page 92. And then is the irrevocable GPA, page 93. Here also, my lord, he admits that I am the owner. Then the money receipts are there. There is one, my lord, additional fact which I need to read, and that is at page, if my lords will have it after lunch.
Yes, I will take a break. For 5
There is
minutes.
one matter before I believe I'm told. There's a matter at 2 o'clock, my lords, that kept specifically. Very great.
We'll
to-
continue after 5 minutes.
Very well. May I? But there is a report.
Yes, there
committed-
was a direction of this court to take judicial notice of the FIR and
and
the
all
11
exhibit
documents.
and all whatever was enclosed along with that
Yes.
FIR.
thereafter what happened, whether trial court has taken.
Yes. That's why I read para 18, my lord.
Yes.
Exhibit A was what the trial court ultimately holds.
Hmm.
Para 18, I just read, my lord, para 20, page 20, page 22.
Yes.
On perusal of exhibit A,
Hmm.
it is seen that 2 numbers of money receipts were enclosed, and taking judicial notice of the certified copy of the 2 money receipts which are in the case record. And then court goes on to find that not a single penny was paid by him because there is this forgery. 2 money receipts which are with the FIR. I'll tell my lord what he does. First, he files the FIR. In the FIR, he encloses irrevocable GPA, agreement to sell, and then 2 money receipts, and one he says is with his lawyer, and he encloses them. The case goes on, my lord, against me. I had to take a pre-arrest bail. This honorable court was pleased to grant me pre-arrest bail in that matter of forgery, cheating against me. Then, my lord, he abandons that case because the report comes in that matter, and that report is what is very important. In that report, it says that there are multiple cases of land grabbing against the plaintiff here, and this case also they are going to invoke land grabbing act against him, and they did so. There's another FIR 1060 of 2015. In that, he is the accused. He also comes to this honorable court, takes a pre-arrest bail. What happens is those 2 money receipts are very important, which I just showed, my lords. Those money receipts are of different amount, different dates. That is earlier of January and March of 2013. When he comes and files his suit, he probably completely, my lord, forgets that he had placed 2 money receipts before the police. He constructs a completely new case saying that I met the defendant first time in September 2013 only. And my meeting with him, physical meeting with him, happens only on 10th of October 2013. And he, my lord, places on record, which are exhibit 2, completely different money receipts of 30 lakh, 30 lakh, 30 lakh. Completely different dates starting from September only. Because now he has given up his earlier case against me that he has paid me 90 lakh. In that also he says he has paid me 90 lakh. But 15 lakh, 40 lakh, and the rest amount of 30 lakh. 30 lakh, he does not give the money receipt, but the date is mentioned in the court order. That date is 12th of August 2013.
Okay.
Then the court, my lord, when we come to know that those money receipts are different, when we inspect the file, that those 2 money receipts are very different from the one which he has filed along with the suit, we asked for recalling the witness. That was ultimately rejected, but the trial court also says, I will grant you the opportunity, take the judicial notice. Because these are the judicial court proceedings. And we challenge that. He does not challenge it. When the matter comes here, this honorable court was also gracious enough to grant or to affirm the finding of the trial court that the judicial notice will be taken. And in so and so light of that direction of this honorable court passed in that revision petition, the court takes a judicial notice. And that is why ultimately at para 21, ultimately courts find that this is a forged agreement, manufactured, void and collusive, and in cooperation and not binding upon the defendant. The last lines of issue number 10, my lord, para 21. Page 23. Now, he does not, my lord, in his appeal also in 111, he hasn't done two things. First of all, my lord, he does not accept me as a landlord or the owner of the property, because his appeal has to be also on this very tenure, that the specific performance suit can only be granted to him if I am the owner, and that's agreement to sell, if he is wanting to be upheld by this honorable court in his appeal law as well, he has to acknowledge me as the owner. He doesn't do that. He does not discard that the judicial notice taken and those money receipts are not his signature. He rather categorically admits in his cross-examination, which I'm going to read, that he signed those two receipts and they are part of the record. And then he does not say anything why the earlier money was given up and the new money receipts were constructed, built, because they don't, unlike those other money receipts, they don't have any witness here. Now there is no witness, there is no judicial stamp, 30 lakh cash, 30 paid by him conveniently, because now he has set up his case 90 lakh. And then they forgot those two money receipts, because at that time, when I deposed and filed it as an annexure C, I did not enclose those two earlier money receipts because they were annexures and we probably glossed it over. And that is, my lord, why I say that this person, my lord, the plaintiff, does not deserve any discretion by this honorable court also. And this is why the court rejected that the agreement itself is forged. Money receipts are forged. And now I am seeking, my lord, rather, my lord, this is a classic case of that Arab and the camel. My lord, I read it when I was a child. He has thrown me out, taken over the possession, FIR against him under the Land Grabbing Act. And my lord, he is enjoying the property because I have failed to get any kind of order of receiver, court receiver, or any kind of order from this honorable court in my appeal. And he is enjoying, my lord, 2.5 lakh a rent for that entire 5-story, which he, my lord, later on constructs, completes, my lord, because I constructed, he finishes it and gives it on rent. For the last more than 13 years, my lord, he is enjoying the property. And then, my lord, I will just read three more things. One is the investigation report by the investigating officer, which is at page 61, typed version. In his FIR, how the police record that he is a land grabber. And then his own testimony that he does not know how he raised that 90 lakh also. He says, I collected from here, I collected from there. And those persons are not or produced as witnesses. No document is shown to the honorable trial court also that how he collected that money of 90 lakh. Because he first of all says, I am a pauper man, I don't have a job. I don't have money to run the business. And then he garners 90 lakh. First of all, he pays me in March 90 lakh. Then he again pays me because he forgot that he has paid me 90 lakh. Again 90 lakh. That is the reason why the court goes on harsh on him, that he has failed to prove his prima facie or discharge the burden. But, my lord, since even though it was an admitted case, the court should have, my lord, under order 12, rule 6, the court should have, my lord, given a part decree against me in my favor, because this was an admitted fact that I am the owner, admittedly. And the sale deed is also, my lord, placed on record. It is just that the court says you have failed to prove that sale deed.
Okay.
And then, my lord, may kindly just have page 61 of my RFA. I'll just read this one page. This is the final report filed by the investigating officer in his FIR 902 of 2014.
Page number?
Page number 61 of my RFA, my lord. This is the part of the same, my lord, certified copy of the which was allowed by this honorable court in the revision.
Hmm.
Short description on final report is that on 15th of May at around 7:30, the complainant Alok Ghosh, so and so, filed written complaint that for a plot situated in Baltota Mauza, mile 6 near Ganesh Mandir, so and so, measuring so and so, he had entered into an agreement on 10th of October 2013 with Shri Chandra Mohan Jha, so and so, about a 3-storied building along with land and paid rupees 90 lakh only against this deal. Now, this we are talking about, Malo, those earlier money receipts. After which Chandra Mohan Jha issued a power of attorney, but even after lapse of 7 months, when Chandra Mohan Jha did not complete the formalities related to transfer of land, then FIR has been lodged and investigation proceeded. The investigator visited the spot and took statement of all concerned. The accused Chandra Mohan Jha was contacted and he appeared before me in PS with a court pre-arrest bail order. He told me that he does not know any such person named Alok Ghosh and he has not sold a 6-mile plot to anybody nor given any power of attorney to anybody. The document he produced established his possession over the plot. To verify the genuinity of the FIR, inquiry was made with the witnesses in the FIR, namely Bipul Singh and other one Anantha Khodan. But both of them stated that they have never met Chandra Mohan Jha and do not recognize him. It was in connection with business that Ananda Khota came to know Ajay Singh, and it was through Ajay Singh he came to Abhijit Ray, Alok Ghosh and Pritam Hazarika. One day in February 2014, Abhijit Ray and Pritam Hazarika made one Jatin Bashia to wait near New Live Building Christian Basti in an Innova car for sale of some land. At that time, no transaction took place. The other witness, Bipul Singh, told that his friend Pritam Hazarika called him in the court on 21st of March 2014 and got my signature on a money receipt as a witness. He did not know what for that money receipt was. That day, no cash transaction took place. He had never met Chandra Mohan Jha, nor he recognizes him. Pritam Hazarika, Ajoy Singh, and Abhijit Ray did not appear before the investigating officer. The complainant, while filing FIR, has mentioned that he will produce original copy of the title deed. But I came to know that after filing FIR, he left for Kolkata and now his mobile is switched off. It came to my knowledge that Alok Ghosh, with the help of few touts, he prepared fake papers and has filed case in the court to grab the land belonging to Chandra Mohan Jha under conspiracy. In this connection, FIR has been lodged against Alok Ghosh YD case number so and so under section 5 of Assam Land Grabbing Act to act upon against Alok Ghosh and his associate. The original deed money receipt is not available, hence tallying of signatures is not possible. Therefore, this case is false and is prayed to the honorable court that this complaint be dropped. The accused have been informed in writing about the finding of the investigation. My lord, it is for this reason that if you see the money, the actual alleged agreement to sell, only witness is my lord PW2, that is Pritam Hazarika. Bipul is not produced, even though he is a witness to the earlier sale deed and he had categorically deposed before the police. And against this, my lord, no challenge was made by the plaintiff herein. This stand as it is. And then coming to, my lord, now his cross-examination. Just have his cross-examination, my lord. That is in file C2. I'm so sorry. Oh, this file is C1, my lord. I'm so sorry. Page number 1. This is his evidence on affidavit. Even though, my lord, I don't know the Bangla language, I'm so sorry. But para 3, my lord, I am told that here he acknowledges that Chandra Mohan, para 2, he acknowledges Chandra Mohan Jha is the owner. And para 3, my lord, he acknowledges that he has taken the permission from the concerned persons. So in his evidence in chief also, he admits that I am the owner. And page 4, my lord, the cross-examination starts. 20th of May 2016. I reside at Lal Ganesh, Gauhati. For the last 6 to 7 years, I have been engaged in real estate business and also used to participate in railway auction. I read up to 10th standard at YWEA school. The volume of work involved in the auction business was around 10 to 15 lakhs. The said business was a partnership business. I have not mentioned anything about my real estate and auction business. I have not produced any document to show that I have ever participated in any auction. I have got bank account in SBI Standard Chartered Axis Bank. I have filed a present suit to get the land register and to get the advance amount back. I know that the defendant has lodged an FIR before Dispur alleging land grabbing by me. I read the said FIR once and twice and I obtained a pre-anticipatory bail from the High Court as my advocate told me. I also felt after reading the Azhar concerning the allegation therein I might be arrested. I was asked by the IO over the phone and accordingly appeared before him at Dispur police station. The IO recorded my statement and took my signature therein. Most probably this investigation has been closed. To my knowledge, apart from me, the Azhar contains the name of one Pritam Hazarika, who is my friend. Pritam Hazarika was introduced to me by my friend Rahul Singh when I reside at Manipur Basti. I do not know what Pritam Hazarika does, but possibly he is not engaged anywhere. I know Ajay Singh also, who is also referred to in the Azhar. Till now, I have not taken any legal step against the Azhar lodged by the defendant against me. I met the defendant for the first time in the premises of the suit land. My lords may kindly mark this happens on 10th of October 2013. Ajay Singh, whose name appeared in the said Azhar, to whom I was introduced by a common friend, for the last 2 years I did not have any work. One Shri Abhijit Ray is the aforesaid common friend who has a shop dealing in recharge mobile cards. The agreement dated 10th of October was handed over to me. Now, my lord, kindly see, nobody sees anyone. So this all happened, my lord, one way or the another in the dark. Was handed over to me by plaintiff on 10th of October in the suit premises. On 10/10/2013, I took Pritam Hazarika along with me, who put his signature on Exhibit 1 as a witness. Exhibit 1 was already signed by the defendant in advance and was handed over to me by the defendant before Pritam Hazarika signed. In Exhibit 1, when I and who signed as Nabajit Sakia, I do not know. Now, Nabajit Sakia is his witness only. I have paid the advance amount of rupees 90 lakh to the defendant by arranging the same from my friends and family members. I do not know from where they arranged this huge amount of cash. I did not mention about the arrangement of aforesaid cash in my plaint. Swati Ghosh, my sister, Abhijit Roy, my friend, are the major contributors of the aforesaid amount of the advance of rupees 90 lakh. I may approach these two persons to appear in this case on my behalf, but till now I have not approached them. At present, I have kept one caretaker in this suit premises. It is not a fact that on 10th of October 2013, the defendant was away from Guwahati. There is no other past record of my such purchase. I have not mentioned anywhere in the plaint that I knew the defendant prior to September 2013. I also lodged an azhar against the defendant, alleging that even after taking advance money, he did not execute sale deed. However, I do not know if the said investigation has been closed by submission of final report. This is the same report, my lord, I just read. After the institution of present suit by me, I did not inquire about the status of investigation pursued by my Azhar lodged on 15th of May 2014. The Azhar contains the name and cell phone number of Pritam Hazarika below my signature as informant. I know that defendant was the principal of CMJ University. Later, though, electronic media, I came to know that the defendant was introduced in some scam related to university. I also know there were criminal cases against him and he was in jail also. In the present transaction, Ajay Singh has not contributed financially. Ajay Singh and CMJ knew each other. Ajay Singh has a hardware shop which is situated near my suit premises. I do not know if Ajay Singh used to supply hardware to the defendant. I do not know who is Bhavan Jha. I know one Mishra ji who might be Anil Mishra. Mishra ji who is an employee of defendant. It is not a fact that I have entered into the suit premises on 12th of May 2014 for the first time. It is a fact that on the day I entered into the said premises, I was accompanied by some person. It is not a fact that I was assisted by Mishra ji and other caretakers from entering to the suit premises. I paid the advance of 90 lakh to the defendant in 3 installments on 3 different dates. On 10th of October 2013, when the defendant handed over the Exhibit 1 agreement already signed by the defendant, I put my signature on the said agreement in the suit premise. After I and Preetam Hazarika put our signature, Mishra ji handed over the Exhibit 1 agreement to me after 2 hours. If the signature in Exhibit agreement of the defendant is not the signature of the defendant, then I shall file a case of forgery against the defendant. It is not a fact that Exhibit 1 is a false and fabricated document manufactured by me to grab the suit premises. I know that the defendant has in the written statement alleged that Exhibit 1 is false document and he never executed the same. Till now, I have not filed any case of forgery against the defendant. During the time Mishra ji took away the exhibit from me after I signed and Preetam Hazarika signed the same, I was sitting in the suit premises along with Preetam Hazarika and CM Jha till the time Mishra ji brought exhibit 1 back and handed over the same to me. It is not a fact that I manufactured Exhibit 1 document and also the signatures of the defendant by committing forgery, and I was provided all assistance by Shri Ajay Singh, who is known to the defendant. It is not a fact that Ajay Singh used it to supply hardware materials to the defendant, and after the defendant stopped purchasing materials from him, he conspired with me to grab the suit land. It is not a fact that I have grabbed the suit premises with the help of my associate Shri Ajay Singh and the local police. It is not a fact that I have not paid any amount of money to the defendant in order to purchase the suit premise. I have not produced any money receipt and any power of attorney as mentioned in my azar dated 15th of May 2014. So, my lord, he knew that the money receipts have been filed and they were put to him in a cross examination, but he denies that. He does not file a case ultimately against the azar, against the closure, and against the criminal case that those money receipts are there, because he does not challenge that either the trial court judgments, my lord, where I was granted the opportunity, nor the order passed by this honorable court allowing the court to take judicial notice. He does not challenge it. So it becomes an admitted fact. Exhibit A is a certified copy of the azar dated 15th of May 2014, lodged by me against the defendant along with the formal FIR. It is not a fact that I did not enter into the suit premises on 10th of October. It is not a fact on 12th of May, I along with some anti-social elements entered in the suit premises and dispossessed defendant from his men, Anil Mishra and caretaker, with a view to grab the suit premises belonging to the defendant. I am aware that on the basis of an application filed by the defendant, our temporary injunction, this honorable court passed an order of status quo, which was made absolute on 19th of February 2015 in Miss J. So-and-so. When I entered into the suit premises, the building was under construction and it is in the same position now also. It is not a fact that Exhibit 1 under objection is a forged and fabricated document and the contents of the said document are all false, and I have not acquired any right over the suit premises. It is not a fact that exhibit was never notarized before the notary public Gyasuddin Ahmed. He is also not produced. It is not a fact that photograph of the defendant was furnished to me by Shri Ajay Singh. It is not a fact that the defendant was never in need of money and he never executed the so-called exhibit document. I do not know if the defendant was in judicial custody. No, this fact is also there. The defendant was in fact in judicial custody when this agreement came to be executed behind the back. In criminal case in Shillong, I knew that the defendant is a person from Shillong between 10th of October 13 and the date of filing of this suit, that is June 14. I did not issue any letter or notice to the defendant to carry out the terms of the exhibit D1, exhibit 1 document. There is a civil case pending against me in respect of a plot of land in Amingao, which is pending since 2007. That land is in my possession. According to me, this is not a relevant question. It is not a fact that I have filed a false case against the defendant to recover possession, and although I have no right to the same and the relief claimed in the suit, it is not a fact that I have let out the said premises to any person now occupying as a caretaker at a monthly rent of to 20,000, and the same is shared equally by me and the police. The next is minor PW2. Only 2 witnesses are there. He is Pritam Hazarika. I'm in a businessman. I'm a businessman. My business is to supply sand and bricks. Alok Ghosh is my friend since 1996. Alok Ghosh as a real businessman, real estate constructor. I am not sure, but he may have a business of land sale and purchase. I saw the defendant in the suit premises when I went there along with the plaintiff. I met the defendant once earlier also when I was accompanied by plaintiff. I do not know Abhijit Ray and Ajay Singh about the need of money of the defendant, which I mentioned para 2 of my evidence in affidavit. I came to know from the plaintiff exhibit 1.5 is my signature in exhibit 1 agreement, which I put sometime in the month of October 2013. Apart from my signature in exhibit 1, who else signed I do not know. I do not know Nabajit Sakia. I do not remember now whether after I put my signature in exhibit 1, I went out from the room and I did not participate in the discussion. After I came out from the room, I did not naturally witness as to who did what. The signature exhibit 1.4 and the signature of Lok Ghosh were already there in exhibit 1 when I put the signature. Exhibit 1.5, I have seen the transaction of rupees 90 lakh. But on the day I signed, only a part payment was made. But I do not know the exact amount. Today, I am not aware as to who is possessing the suit premises. I do not know whether Lok Ghosh has the capacity to pay 90 lakh, but according to me, he has paid the money. But from where he has arranged this money, I do not know. I do not remember whether Lok Ghosh told me even that he has 90 lakh to purchase the suit land. I believe that plaintiff may have a cash amount of rupees 90 lakh. I do not have any personal data of the plaintiff, like details of bank account on the other sources based on which I can confirm that the plaintiff has had the financial capacity to arrange a cash amount of rupees 90 lakh. I never asked him from where he will arrange 90 lakh. I remember the plaintiff lodged an azhar in Dispur, and I accompanied the plaintiff in that day. I did not write my name in the azhar below the signature of the informant. I heard that the defendant issued money receipt to the plaintiff, which is mentioned in Exhibit A, azhar about my any power of attorney as mentioned in Exhibit A. I have no knowledge. I know that the defendant also lodged an azhar against the plaintiff in Dispur PS. I was interrogated by the police in connection with the investigation on azhar lodged by the plaintiff being Dispur number so and so. I know that on want of sufficient material, the police submitted FR in connection with the azhar submitted by defendant. Also, I was interrogated. This is in the same FR. I remember to become successful in the job of acting as a broker in the sale and purchase of land in Kharguri area. This activity of brokerage is part of real estate business which Alok Ghosh has, but I have no knowledge in how many cases he became successful. This business of brokerage, according to me, is illegal, and if there is no registration in my lifetime, I have not come across any registered broker. I have no share in the present transaction as deed. I do not know why FR was submitted in Dispur police station case 902. I know that there is a law in Assam known as Assam Land Grabbing Act. Alok Ghosh stays in Silpukri in his own residence where I visited. Alok Ghosh says different thing. In his own residence where I visited sometimes in the past. I do not know if plaintiff has any other house in Gauhati. Plaintiff's parent stays in Lal Ganesh. That's what he ultimately says. I know Bipul Singh who stays in Manipuri Basti and a common friend of the plaintiff and myself. He has a grocery shop and now from a SIM card he becomes a grocer. It is not a fact that I, along with the plaintiff and some more persons, are engaged in land grabbing activities in Gauhati, and we have been trying to grab the suit premises by manufacturing document including Exhibit 1. I am a bachelor and plaintiff is also a bachelor. I do not know if the suit premises is let out and the rent realized therefrom is shared by the plaintiff and the police. Since copy of the power of attorney and 2 number of receipts are mentioned in Exhibit A, Azhar, those documents should be there. I don't remember if I took the signature of Bipul Singh as a witness on 21st of March 2014 on a money receipt as a witness by calling him in the court. It is twice that the cell phone's number mentioned below my name in Exhibit A is my phone number. It is not a fact that I have some to depose as a witness in this case to help the plaintiff by stating falsehood. I don't know if Exhibit 1 was notarized. Now, my lord, the plaintiff says that he had not filed those two money receipts. PW2 on which he relies upon says he had in fact signed those two money receipts, which are enclosed with the Azar. So the whole case, my lord, is something, my lord, which the trial court takes a judicial notice and says 90 lakh he neither has himself nor he has produced any witness to show that he could have arranged it. Now come back to, my lord, the impugned order. Just few more, my lord, lines, and I will just finish off. Issue number 4, my lord. This issue is whether the defendant has entered into an agreement on 10th of October 2013 with the plaintiff for sale of suit land to the plaintiff. PW1 is the plaintiff in his affidavit evidence deposed that the defendant is the absolute owner and possessor of land measuring 1 kattha so and so. I would not read. PW1 also deposed that in the month of September 2013, the defendant approached the plaintiff with request to sell the suit property. And on 10th of October 2013, the plaintiff and the defendant entered into an agreement for sale. And the price for the suit property fixed at rupees 1 crore. And the defendant accepted advance money of rupees 90 lakh from the plaintiff on the date of execution of the agreement for the sale and handed over possession of the suit property to the plaintiff. The PW1 also deposed that as per the agreement, the defendant was to take necessary sale permission for the execution of, but the defendant on one pretext or the other avoided to obtain the permission. PW1 so and so 6th of January 2014, the defendant assured the plaintiff that the sale permission would be obtained shortly and sale deed would be executed. But the defendant again did not make any attempt to obtain the sale permission. And when the plaintiff approached the office of the deputy commissioner, he found that the defendant has not applied for any sale permission. PW1 also deposed that thus seeing conduct of the defendant, he came to a conclusion that defendant, despite receiving 90 lakh as advance from the plaintiff, was not willing to so and so. Exhibit 1 is the agreement for sale dated so and so. Exhibit 1 to Exhibit 1 by 4 are the signatures of the defendant. The defendant as DW1 denied that he executed the Exhibit 1 and also denied his signature in Exhibit 1. DW1 deposed that the plaintiff on so and so, along with some person, forcibly entered the suit scheduled property by breaking in the lock of the main gate and drove out all the workers and illegally took possession of the suit property. DW1 deposed that on the day and the time he was in judicial custody in FIR was filed on his behalf by Shri Bhavanand Jha on 2/6/2014, which was registered as Dispur case number. That exhibit sees the FIR dated 2/6. DW2 in his affidavit is corroborated. Did not enter into an agreement for sale in respect to the suit property and also deposed that he filed Exhibit C on behalf of the defendant and admitted his signature Exhibit C marked as Exhibit C by 1. PW1 deposed that the agreement dated that is so and so was handed over to him by the plaintiff on 10th of October 2013 in the suit premises, and on that day, Pritam Hazarika went with him to put his signature in Exhibit 1 as witness. PW2 Pritam Hazarika in his evidence deposed that he signed exhibit and his signatures is marked Exhibit so and so in his cross examination. PW1 deposed that apart from his signature, he does not know who else signed Exhibit 1 and deposed that after putting his signature, he went out of the room and cannot say what happened thereafter. PW2 deposed that signature of the plaintiff marked as so and so was already there on exhibit before the PW2 signed it. PW1 in his cross examination also deposed that Exhibit 1 was already signed by the defendant in advance before it was handed over to him and before the PW2 signed it. From the above discussion in respect of the execution of Exhibit 1, it is seen that Exhibit 1 was not executed in the presence of the plaintiff, as PW1 deposed that Exhibit 1 was already signed by the defendant prior to handing over the same to the plaintiff. PW2 also deposed that the time when he signed the Exhibit 1, the signature in Exhibit 1 marked as Exhibit 1 by 4 of the defendant was already present. This means that the exhibit 1 was not signed by the defendant in presence of PW2 in exhibit 1 as a witness of the deed. From the evidence of the PW1, it is apparent that the defendant did not put his signature in exhibit 1 in his presence. The defendant denied his signature in exhibit 1 in toto. Moreover, PW1 and PW2 could not recognize the person who signed the exhibit 1 as a second witness. The position being so, as PW1 and PW2 both did not see the defendant sign exhibit 1, and as the defendant denied his signature in exhibit 1, there is some doubt regarding the execution of exhibit 1 by the defendant. The plaintiff, moreover, did not take steps to send the signature of the defendant in the documents for the expert opinion so as to ascertain whether the signature in exhibit 1 marked as exhibit 1 by 3 and exhibit 1 by 4 are that of the defendant or not. And then some judgment is mentioned. From the above discussion, it is seen that the plaintiff failed to discharge the initial owners, as the plaintiff failed to show so that the exhibit 1 was executed by the defendant. PW2 also called witness also stated that the exhibit 1 was already signed by the defendant before he had signed it. PW1 deposed that when the exhibit 1 was handed over to him, it was already signed. So none of the PWs saw defendant execute exhibit 1. Thus, PW2 cannot be said to be the witness of exhibit 1 as the same was not executed in presence of the plaintiff or PW2. The defendant denied his signature in exhibit 1, and in view of exhibit 1 not being executed in presence of the plaintiff or PW2, and also as the plaintiff failed to prove the signature of the defendant in exhibit 1 marked as exhibit 1 by 2, by examining the same through expert, it cannot be said that the defendant entered into an agreement on so and so between the plaintiff and to sell the plaintiff. This issue is decided in the negative and against the plaintiff. But I will just make a small correction here. The defendant did admit the signature. That is their star argument in their appeal. I did admit my signature, but I denied the contents of all the exhibit 1. And the law is, my lord, right from the very beginning, Privy Council also, that not only the plaintiff is to, my lord, prove the signature, or anyone who is actually relying upon some document to prove the signature, but also the contents. Now here the controversy is, my lord, which I see is gonna be forthcoming. The contents are also not proved by the plaintiff, because none of the plaintiff witness, including himself, my lord, saw it to be signed. They did not prove the contents also. The money receipts are allegedly held to be forged. So the admission of signature by the defendant, only the signature, my lord, I will rely upon that judgment also, that merely admitting the signature is not enough to prove a case against the defendant or against anyone. And my lord, there is one factor which I must first of all argue, and that is, my lord, section 58 of the Indian Evidence Act. Section 58 of the Evidence Act, my lord, clearly postulates facts admitted need not be proved.
Yes.
No fact need to be proved in any proceeding which the parties thereto or their agents agree to admit at the hearing, or which before the hearing they agree to admit by any writing under their hands, or which by any rule of pleadings in force at the time they are deemed to have admitted by their pleading, provided that the court may at its discretion require the facts admitted to be proved otherwise than by such admissions. Now, my lord, right from the plaint, the rejoinder, or the counter to my counterclaim, in his, my lord, cross examination, his evidence in chief before the police, my lord, my lord, he has categorically admitted that not only I am the owner, I have also given him the sale deed which was in my favor, executed by Upendra Chandra Chaudhary in the favor of the defendant, and he is the owner. And not only that, that is why I was reading in para 2 also in the plaint, he says that the defendant has sought the permission to construct also, which he had sought. So there was no question on the part of the trial court to say and return a finding that I have failed to prove my title. because as per order 12, rule 6, just give me the CPC. The facts admitted, the order should have been passed under order 12. Admissions. If my lord may just bear with me with the judgment on admission. I have got one judgment to also buttress my argument. This is the order 12, rule 6, judgment on admissions. Where admissions of fact have been made either in the pleadings or otherwise, whether orally or in the writing, the court may at any stage of the suit, either on the application of any party or of its own motion, and without waiting for the determination of any other question between the parties, make such order or give such judgment as it may think fit, having regard to such admission. Whenever the judgment is pronounced under sub rule 1, a decree shall be drawn up in accordance with the judgment, and the decree shall bear the date on which the judgment was pronounced. Now, my lord, there is a categorical admission time and time again, and the issue is framed, but the court says I still needed to prove it, and without giving me an opportunity to prove it also otherwise, the court goes on to return a finding that I'm
Whether you have not been allowed to adduce evidence.
no, my lord, I was not asked by. That's why I was reading the rule 58. Kindly have with me again rule section 58. Section
No,
58
that's
also.
all right. The provision is there.
The provision is the proviso.
Hmm.
The proviso says that the court may, in its discretion, require the facts admitted to be proved. The court did not do that, my lord.
Hmm.
Court did not even put to me, and I was under the, my lord, under the impression that he has admitted, and this is a suit for specific performance, my lord. Suit for specific performance is a sine qua non that there are two parties, buyer and a seller.
Hmm.
And I was under the wrong impression, my lord. Or maybe the rightful impression, but proved wrong by the court's finding. And the court still goes on to say that partly allowed.
That's all right. But under what circumstances you put your signature in the exhibit 1?
I'll tell my lord. My lord, I showed that the signatures are mine, but the contents are not there.
No,
I'll
that's
read
all
that
right.
judgment.
Under what circumstances you put your signature
I'll tell my
over
lord,
the
but
exhibit 1?
I had explained that also. There was one Ajay Singh, which reference is all there. But Ajay Singh was my constructor. He was my contractor. The contractor had in his possession my empty signatures also for taking out various my lord, permissions and everything else. And those signatures were ultimately, my lord, utilized by them, and that is why they are all under the Land Grabbing Act. But the contents, my lord, there are two factors, my lord, here. One, the plaintiff was still required to discharge the burden of proof, my lord, which was upon him, first of all, to dislodge that the contents are also proved. Then the burden, my lord, shifts upon me. Here the burden never shifts. If the burden has never shifted, my lord, there was no occasion for me to prove it anyway. But the court goes on to say it was on the burden upon him to actually, still prove his signature. Whereas the thing should have been the contents were also supposed to be proved. And the court returns a finding that the contents are also wrong because nobody saw him signing, even though my admission is there. And I will read that judgment. First of all, I read one judgment under, my lord, admission. And that is the Supreme Court's latest judgment, my lord. Court master. I'll give a copy to my friend here. This is under the Rent Control Act, my lord. I'll just come to page, my lord, para 9, page 2. In such circumstances referred to above, the plaintiff had to institute the title suit for recovery of the possession. The defendant filed his written statement, and in the same, he is said to have admitted few facts arising thereof. The defendant in his written statement admitted the following claims of the plaintiff. The defendant unequivocally admitted in para number so and so of his written statement that Ranjan Ghosh was the sole tenant in respect of the suit property. The said Ranjan Ghosh passed away on so and so, leaving behind the defendant as his heir and legal representative. The defendant admitted that the plaintiff is the owner of the scheduled property and the rent was paid till so and so to the plaintiff. In view of the aforesaid admissions made by the defendant in his written statement, the plaintiff preferred an application before the trial court under Order 12, Rule 6 of the CPC Code and prayed as a decree upon admission. The application filed by the plaintiff under Order 12 of the was opposed by the defendant by filing reply which read thus. I may not read all that. Para 12 at page 4. The trial court adjudicated the application and ultimately decreed the suit having regard to the specific admissions made by the defendant. The defendant being dissatisfied with the decree passed by the trial court based on the admissions challenged the same before the High Court by filing so and so. High Court dismissed the FAT holding as under. And then the case law is also discussed. I may not read, my lord. Then para 19.
So this judgment is upon a judgment on admission.
There, but though my case is also, my lord, he categorically admits everywhere, my lord, in the plaint also. My contention is, my lord, in my appeal is very limited to this ground. Leave apart, my lord, he will have his own case. My case is very simple. That if my appeal is, my lord, filed before my lord to content only this much, that in his suit for specific performance, my title came to be adjudicated and the court rejects it. And he categorically admits everywhere, my lord. Where is the question for me to, my lord, prove it otherwise also? And assuming so, my lord, if that be so, my lord, if I am not held to be the my lord, the owner of the property before this honorable court also, his appeal, my lord, is anyway piggybacking me. His appeal is primarily on the ground that I have admitted my signature on the forged agreement, and on that account only his appeal be allowed and specific performance decree be granted to him. If I am not the owner, my lord, his appeal, he would not have filed an appeal also. That is why I filed a application, my lord. That's where the application now comes in play, that the property is in mendio, and that is in limbo. And so many judgments are there, my lord, that if the property is neither here nor there, my lord, this honorable court is to protect that property. Otherwise, my lord, what would happen? The property has to be escheated back to the state. If I am not the owner, he has been divested of his right under the Exhibit 1.
Okay, where is the plaint?
A plaint is, my lord, in the application which I had filed, my lord.
Page number?
Page number is, my lord, in the application it is in. Acha, in 111, my lord, that plaint is at page 11. Annexure 1 in RFA 111.
Okay. So
plaint,
annexure 1 is in the IA is the
no, my lord, not in the IA. If my lords may kindly have his RFA 111 of 2019. Item 32, my lord.
no. In the IA filed by you.
Yes, in the IA, IA is,
It
my
is
lord.
annexure 1.
Yes. 2813, my lord. Page 6. His plaint starts with the defendant is the absolute owner. Admitted fact, my lord. Once it is clearly admitted, there was no question of framing an issue. And even if issue has been framed, my lord, there was no question to lead any evidence also.
And where is your counterclaim?
Counterclaim is at, my lord. If my lord may kindly have, then T. File A, my lord. File A has got everything, my lord. The suit, the written statement.
No, in your IA annexer 2 is the counterclaim.
My lord, in my IA, pair 19,
Yes.
page 19. Para 8, my lord. With regard to the statement made in paragraph 1 of the plaint, the answering defendant admits that the defendant is the absolute owner and possessor of the plot land. And then para 21 and 22, I again mention the same thing, to which he responds through his counter. But that is not there. But that, my lords, have to.
But Mr. Singh,
Yes, my lord.
you come to page number 28
28. Yes, my lord.
of your IA.
Yes.
That is the pair portion of your counterclaim.
Yes. I sought the decree, my lord. I'm not denying. That's why I read everything to my lords. Nothing hidden. I read prayer B and prayer D.
So here you have prayed for declaring right title and
Yes.
interest over the suit property.
Yes, and I paid ad valorem court fee also. No doubt about it. But that's where, my lord, the Order 12, Rule 6 and Section 58, my lord, comes in foreplay. That if the facts are admitted, the judgment has to be given. There's nothing to adjudicate left. And that is the reason, my lord, I may not have, my lord, filed the registered sale deed, but executed between Upindra Chaudhary and myself before the trial court, because this was an admitted fact and it was a suit for specific performance, my lord. I may have turned, my lord, wrongly into a declaratory suit. But the fact remains, my lord, the law is very crystal clear, and that is why I read this judgment of the Honorable Supreme
No,
Court.
you see,
Hmm.
in your counterclaim, you have prayed for decree for declaration of
Yes,
right title and
the court
interest.
was bound to go into
Whether
it.
the court is not bound to go through.
Court was bound to go into it.
Yes.
But then the court was also bound to, my lord, as per my understanding,
Mm.
the foreplay of played by Section 58
Mm.
as well as Order 12, Rule 6.
Mm.
That is why I read court on its own motion also. My lord, in this case, which I just referred, application was made. But there is a provision, court on its own can also do that, because this is an admitted fact. And my lord, it is a suit for specific performance.
No, that's all right. Had it been only his case, then it is all right. But you have filed a counterclaim
Yes.
praying for declaration of your right title. and
Wrongly
interest
filed, my lord.
over
I
the
was
suit
put this
property.
on the very first day also, my lord, in
Mhm.
2019, the same question. And I responded, my lord, by today also, my lord, with the new judgments are there,
Mm.
that once facts are admitted, my lord, nothing need to be proved thereafter.
Mm.
And my lord, his appeal, my lord, look at the other way around. Look at how the whole scenario will go. If the suit was, my lord, supposing the court would have rejected his specific performance suit.
Mm.
But in the meantime, my lord, he had now, there's another, my lord, only another argument. In his, my lord, 13 and 1 and 2, he has been granted not just the status quo. The status quo is status quo in respect of possession of suit property as on today till disposal of the main suit. That is the ultimate, my lord, relief which he got from the trial court by filing 13 and 1 and 2. He admits in his plaint, in his evidence, in his cross and every other, my lord, document that I have given him the possession. And in my suit, my lord, I had prayed for two things. One is the declaratory suit, and the second prayer is possession back. That is my prayer D. The court does not reject prayer D.
Whether any issue was framed on this point?
No, because the issue is only framed issue 10. Whether I'm entitled for my counterclaim or not. But then the court ultimately in its last leg, last observation, court says that counterclaim partly allowed. My lords may kindly have that same impugned order.
Mm.
Court says counterclaim partly allowed. But I asked myself, what has been allowed then? I may not have got the declaratory suit, but this restitution, my lord, which he got ex parte order from the trial court, my lord, by virtue of his suit being dismissed, because his suit, if you kindly have his suit again, my lord, one of his prayer is to allow him to continue with the possession. If that is also rejected categorically, then I am entitled, my lord, what the court may have meant, my lord, by the learned judge through the impugned judgment, by allowing my at least my possession should have been restituted. And that's what the judgment of the Supreme Court is. The restitution under section 144 also. This honorable court is also, my lord, ultimately can grant me the relief of, if not the declaratory suit, my restitution has to be allowed, my lord. If everything, my lords, are to disagree with me that the court did the right thing because I wrongly filed a declaratory suit, it was rejected.
In spite of the fact that you have failed to establish your right, title, and interest over the suit.
Because that fact of having the possession and having a decree, ex parte decree, on the basis that he showed to the learned trial court that he has got into possession. If I read his, my lords may kindly have his application also, 13 and 1 and 2. He says that I have given him the possession and this court is to now protect it. And the court grants him, my lord, ex parte stay on that very day, 16th of June 2014. If everything is to fall, my lord, I am saying only this much, that if my lords are to disagree with me on every aspect, this is a suit for specific performance. He got the possession forcefully and the court records that finding. That finding is recorded against him. And the restitution has to be allowed. And supposing my lord are to dismiss my appeal, supposing his appeal goes, my lord, automatically. My lord need not even hear a word from him, because he can't get any relief from this honorable court. If I am not the owner, there is no third person also. No legal heirs of or Mr. Upendra Chaudhary, who has come in the trial court or before this honorable court or before the police while it is investigating, that they are the actual owners. And Mr. Chandra Mohan Jha is also not the owner. Police found me the owner. That finding he does not challenge.
No, on the basis of police report, court cannot grant.
I'm
a
not saying grant me. I'm just saying I'm narrating the circumstances here, my lord. I'm only the facts. And facts are there.
Why you could not produce the?
I have produced it here.
That sale deed.
A sale deed has been produced here by my application 2812. I sought the permission under order 40. 41.
Application.
Yes. My application notice was also issued, and they did not file a response also. No doubt that if that ipso facto would not entail that my application is allowed. Just get the file. 2812. Yes.
No.
2812.
Question of allowing this application prior to hearing of the appeal does not arise in view of the decision of Ibrahim Uddin.
Please, my lord.
So this application is here.
Application is there, my lord.
It has to be heard along with the appeal.
My lords, here, my lord, again, this application also, because this will, my lord, throw a great light on because it need not even be, it is up to my lords whether to ask to prove this before the trial court, because ultimately, my lord, this is an admitted fact. He can't even deny that.
Mr. Singh, before advancing your argument, you could have pointed.
I'm so sorry, my lord. I thought this application notice was already issued. He has not filed his response, and this application is there. Otherwise, before the trial court also, my lord, during my stay application, I had filed the sale deed copy. So this agreement is there, my lord, between Upendra Chaudhary and the defendant.
Yes, you have not preferred any objection, though liberty was granted to you.
Lordship, as far my knowledge goes, actually, I have not received it yet. Actually, I have been appointed, say, earlier, say, 8, 9 months back actually. So this I have seen over here, but I don't think it has been given to me as of right now. Only the latest IA which
No,
was
no,
filed in this.
Later on, if someone else is appointed as advocate, then can the applicant is bound to furnish a copy to that advocate also? Because this application was filed on 13/9/2022.
39.
But 19th of August 2019.
This application was filed
No,
on.
this order was passed on 13/9/2022.
20, Jonna,
13/9/2022.
2022. Actually, at that time, I was not in board, but the file which I received from my client actually did not have that particular IA which my lord has been mentioning as of now. But in the RFA, I think RFA of there, I found it this one actually. So right now, after finding it, after a gap of say 3, 4 years, I don't think that it should be replied as of now.
Why?
It has already been
No,
3 years.
there is a decision of Supreme Court that such an application should be heard along with the appeal. We are hearing the appeal today.
Your Lord, I am ready to do my arguments on that also. I also.
This
I am
IA
ready
also. This IA also.
Yes, both the IAs. That IA also and 2 days back whichever one. I am ready for it.
Okay, we will resume at 2 o'clock.
Very well. Grateful.
Then, Mr. Singh, if a copy of this IA is available with you,
Man, I'll just give him a copy.
but
I have
a copy.
rather this is in the court file also in the original record. This was already there. But the fact of matter, what the court records is I failed to prove it.
Hmm.
It was already there, and how they can't even deny this because if I don't have a right to title, they don't get anything.
Mr. Singh, you see, had there been no counterclaim,
I'm just
then
let
the
I'll
matter
just
would
give him
have
a
been
copy.
entirely different.
I'll just give him a copy. He can respond to this also.
Okay, we will resume at 2 o'clock.
Grateful.
1 to 5.
Any other date?
Let it be on 11, my lord.
11.
11.
Okay.
Thursday.
Thursday. Thursday.
Yes, 11.
Okay.
Please, your lordship.
Yes.
Lordship, our item number is 16. It will take, so it may come on, very,
Next Thursday.
next Thursday, your lordship.
Thursday.
It's a partner matter.
No, it is not part.
Okay, then on 16.
16,
16 June.
Well, what is the matter?
MSCT appeal, lordship.
Appeal. So, this you. Get it over 16. Okay, 16.
Much obliged.
Number
16.
Yes, Mr. Singh.
I had-
What is
I
your
had
pair
given
in
the
this IA
I had
now?
given the copy to my learner friend also. This is
Yes.
an application, my lord,
Yes.
under order 41 rule
27.
27
Yes.
for placing on record
Hmm.
the additional evidence. The copy of the deed of sale
Hmm.
between Upendra Chaudhary and the defendant,
Hmm.
the main suit. And this is the one, my lord, which was relied upon by the plaintiff throughout in his evidence before the police also, in his evidence, in his plaint, that he knows about the execution and the registration of this very document. But we did not produce it on our account, my lord. We were under the impression that being a suit for specific performance, we need not place it on record.
No, Mr. Singh, you see the requirement of the provision.
Yes. Kindly have, my lord, I'll read that.
27.
I'm so grateful that my lords have put this query. Kindly have 27.
Yes.
Oh, sorry, order 41, 27, remand 27. Yes, production of additional evidence in appellate court.
Mm.
The parties to an appeal shall not be entitled to produce additional evidence, whether oral or documentary, in the appellate court. But if the court from whose decree the appeal is preferred has refused to admit evidence which ought to have been admitted, or the party seeking to produce additional evidence establishes that notwithstanding the exercise of the due diligence, such exercise was not within his knowledge, or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed, or the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment, or for any other substantial cause, the appellate court may allow such evidence or document to be produced or witness to be examined. Wherever additional evidence is allowed to be produced by an appellate court, the court shall record the reasons for its admission. Now, my lord may immediately have section 165 also of the Indian Evidence Act simultaneously. Judges 165, my lord. Judge's power to put question or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor, without the leave of the court, to cross-examine any witness upon any answer given in reply to any such question, provided that the judgment must be based upon facts declared by this act to be relevant and duly proved. Provided also that this section shall not authorize any judge to compel any witness to answer any question or to produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive, if the questions were asked or the documents were called for by the adverse party, nor shall the judge ask any question which it would be improper for any other person to ask under section 148 or 149, nor shall he dispense with the primary evidence of any document except in the cases hereinbefore accepted. Now, that is the reason under 58, my lord. If the everything admission is already there, and my lord, this exercise has not been done, or on my failing also, the failure of which would incur injustice to any party, either me or him also, this honorable court, by exercising powers consistent with order 41, rule 27, read with 165, can actually take into account the admitted fact. This fact is an admitted fact, and it is not a disputed fact also, and it is not improper or coming under any of the exceptions as enumerated under the proviso. So this honorable court, I beseech upon the conscience of this honorable court, my lord, to allow us to produce a document which otherwise is an admitted document. And
No, that's all right. But what about this explanation as provided under Rule 27?
27, yes, I'm coming under B. I'm coming under B now. B is the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. I'm covered under B, not under A, my lord. A and double A. My lord, double A also I am not wanting, my lord, to get covered under double A, because here the circumstances have, my lord, created a situation where there is a vacuum created by the impugned judgment. But had it been a declaratory suit, I would have still understood. here is a question case where the relief which he would have got by filing of a suit was dependent upon me being someone or having some authority under law or entitlement, which is admitted by him, and yet the court refuses on the ground that I had failed to prove an admitted fact also. Under that circumstances, the B would be most applicable, my lord. And that is the reason, my lord, I did not file it on my own. But when the matter came up for on the admission stage and the initial time, my lord, we were put a question that where is this sale deed? Why have you not annexed it here? But we put it there, and the matter was heard. My friend wasn't there. I was there, my lord. And that is the reason we filed it. And ultimately, court said we will examine it at the time when the matter is heard finally. Then, my lord, 3 times the matter has been argued, and this is the 4th time we are arguing. Ultimately, my lord, we have now converged at a very fag end, and this would be otherwise a very cause of injustice to me, my lord. I am deprived. I am being deprived of my property, which otherwise is an admitted fact. I should not have asked for the prayer B, my lord, but prayer C has already been granted to me, and I am only under the specific performance that for it is sine qua non to me being the owner of a land, my lord, even though I should not have sought a declaration. That was wrong on my part, my lord. We probably should not have done that. But for that, my lord, we could not have been punished to this harsh reality, my lord.
No, the
Deprivation of a
question
property.
punishing does not arise.
My section, otherwise Article 300A also, my lord, does not entitle anyone to deprive anyone of
No,
the
that's all
right to
This
property.
is not a writ
But
petition.
I'm just pointing out,
Ah.
this is only to beseech my lord's conscience that my property rights have been divested without it being acquired, without it being, my lord, taken away. I have sold it. The sale agreement has been found to be forged, but I have been still stripped of my right to property.
In the counterclaim, you have prayed for declaration.
I totally foresaw that, and that is the reason I
And
read
you
all my
failed
prayers.
You failed to enclose and exhibit the sale deed based
Yes.
on which you were claiming your right, title, and interest over the property. Anyway, yes, what is your contention in
There is
respect
only
of this?
one judgment. Uttaradi Mutt, my lord, I'll just give you one more.
That is referred in the application.
No, my lord, it is referred in the application also.
Yes.
This is I'll give a copy to my lords also. 11th. Where? This starts off, my lord, this is a judgment of the Supreme Court 2018, volume 10, SCC 484. My whole case is based upon this, my lord. Titled as Uttaradi Mutt versus Raghavendra Swami Mutt. And
Which paragraph you are
para
relying
20, para 20, my lord.
Para 20.
Yes. Para 13, it starts additional evidence. The further grievance of the appellant, my lord, may have para 13. Para 12, my lord. Sorry. That takes us to the second contention raised by the appellant that even if there was sufficient ground for allowing the stated applications filed by respondent defendant for production of additional evidence, the genuineness and the contents of additional document would have to be proved by party placing reliance thereon. As regards this plea, we find that the High Court has made it amply clear that the fact that the applications are allowed per se is not to give any direction to straightaway exhibit the additional documents, but that it could be exhibited subject to proof. The High Court has unambiguously observed that the documents will have to be proved in accordance with law. We make it amply clear that by allowing the 3 applications filed by the respondent defendant under Order 41, Rule 27, it would not follow that the additional evidence can be straightaway exhibited. Rather, the respondent would have to not only prove the existence, authenticity, and genuineness of the said document, but also the contents thereof. as may be required by law. The further grievance of the appellant, however, is that the High Court in any case ought not to have relegated the parties before the trial court with the direction to the trial court to redecide the suit. The respondents, however, would rely upon the provisions of the amended Rule 23 CPC as applicable to the state of Karnataka. Since it is not state of Karnataka, my lord, it is per se only 2023, and it is a remand. Indeed, the provision as applicable to the state of Karnataka is not limited to the decrees disposing of the suit on a preliminary point, but also where the appellate court is reversing or setting aside the decree under appeal, considers it necessary in the interest of justice to remand the case. Notably, the Karnataka amendment has been introduced by the Karnataka judgment. Then, my lord, para 21. Various modes are given, my lord, of taking additional evidence. So, para 21. Accordingly, we set aside the impugned judgment and order of the High Court in part to the extent that it has relegated the parties before the trial court for redeciding the suit after allowing the respondent defendant to produce the additional evidence in accordance with law. Instead, the appeal is restored to the file of the High Court to its original number. The High Court shall frame points on which the additional evidence is allowed to be produced and direct the first appellate court to take the additional evidence on record in accordance with law, and then return to the evidence of the High Court together with its finding thereon and the reasons therefore within the prescribed time. Such directions be issued by the High Court expeditiously, preferably within 2 months from today. On receipt of the said report from the first appellate court, the High Court may then consider the second appeal on the substantial questions of law already framed on such other substantial questions of law that may arise for its consideration. The appeal and the accompanying application disposed. Now, my lord, here is a proposition. Unlike here, the documents are, my lord, objected to. Here, I believe my learner friend may not object to a document, because if I go, his appeal, my lord, has to be naturally, my lord, set aside right then without it being heard, because his appeal is, my lord, subservient to my appeal. If I fail as a owner of the property, he can't get any kind of relief, my lord, or any indulgence from this honorable court. And ultimately, he has admitted these facts. And one more fact, my lord, and that is one argument which my friend has taken, that the appeal which we filed in 2019, there was some kind of a defect in the power of attorney and the wakalatnama. We have cured those defects also by filing an application bringing on record the wakalatnama of the actual appellant. That was filed on 16th of March 2026. And then the defect in, my lord, verification wakalatnama, my lord knows Supreme Court judgments are Constitutional Bench judgment is also there of FA Sapa versus Signora, that these kind of procedural defects must not, my lord, come in the way of substantial justice. And that's my whole prayer is that the defect which was earlier there has already been cured when we were put to notice, and it was anyway a curable defect. As regard, my lord, his appeal I have not argued, because there are substantial number of judgments in his appeal, because his argument is there that once I have admitted my signatures, then ipso facto exhibit 1 is my lord proved. To that extent, my lords may give me time and patience, my lord. A small hearing after my friend finishes, first of all, addresses the issue whether he agrees with the additional document or not.
This cell date is a registered cell date?
My lord, we had filed now through Harshit. Sorry.
No, registered sale deed.
The registered sale deed, yes, my lord. That is Upindra Chaudhary. It is a registered document. Page 7. Upindra Chaudhary, my lord. Thereafter, I, my lord, got permissions from the concerned department to construct my building, give my plan for sanction. Sanction was also being granted, and that is forming part of this. This very kindly have the authority letters, my lord, or the concerned permissions from the various departments at page 25. Not only permissions, no objection certificate is also there. This is issued by the Office of Gauhati Metropolitan Development Authority, Gauhati, dated 22nd February 2012, to Shri Upendra Chaudhary. Subject is no objection certificate for sale transfer of land under section 31, read with section 32 of the GMDC as amended. Your application dated so and so. This is to certify that the Gauhati Metropolitan has no objection to transfer
Okay,
the plot
okay.
of land measuring.
Whether the original copy is available? with it?
Yes, my lord. Original copy, my lord, we have to just check. I'll tell my lord what happened when we were, there was this incident or FIR lodged in Shillong. Everything was seized. So I have got the certified copy instead from the department, as well as certified copy of this very letter from the office of the Gauhati Metropolitan
No,
Development.
this is not certified copy.
But this is a true copy, my lord. We have got the certified. It is a certified.
No, we cannot admit this as secondary
I'll
evidence.
just I can produce him, my lords. May give me some time. I'll produce the certified copy. I have got the certified copy from the department.
Then can we complete the hearing today on this?
My friend, if my friend agrees with this document, my lord, then nothing would survive. It is an admitted document then, provided my friend agrees. If my lord may pose a query to them in case they want to object to this document, then of course, then I will go through as per the law, my lord, laid down under order 41. 161, otherwise 165 entails my lord's power. But I don't want my lords to go to that extent. We will supply, if my learner friend is objecting, we will file the certified copy, my lord. We can produce it, my lord may make it subject to production of the certified copy, whatever my.
Yes.
My lord, there are two RFAs actually, which came after, it is of the order dated actually 12/6/2019 on TS number 205/2014. RFA 73 is of test and RFA 111 is the number. And along with them, they have filed two IAs actually. One is 2812/2019. This states ki the now what we have found the sale list to be exhibited here, and now 1830/2026 IA, it simply says that the court should appoint a court commissioner. Now, when I first begin with their RFA actually 73/2019.
No. First, we have to dispose of this I-2812 of 2019. Yes.
Your Honor, if want to dispose of this 2A12, it says a true copy of sale deed, registered book deed number 19302012. They have to produce the original copy, and they were not in a position to originally exhibit at a trial court. Why? Because that original sale deed is with me. Now, how I came into the holding of their original. Now the thing is that my lord, if on the RSA 73, my FIR is there actually. Your logic, if I turn to page number 68, is my FIR which I filed in the officer in charge of the dispute police station actually. It is on the 15th of May 2014. The type copy is
Page number?
68. Type copy is at 68 and main copy, the certificate copy is from 70 to 71, 72. Now, may I?
No, in your RFA.
in the RFA of dash 73/2019.
Page number?
Page number 68. My lord, my lord, got it? 68 number.
Yes.
Sir, with due respect, I beg to inform you that last year in the, on such and such date, I have entered into an agreement with Sri Chandra Mohan Jha, son of such and such, aged about 59 years, by religion Hindu, resident of such and such, Shillong, district East Khasi, Meghalaya, in regards to a plot of land measuring 1 kata 17 lesses, covered by so and so. Assam, along with a G+3 story RCC building standing in the aforesaid plot of land situated by the side of Ganesh Mandir High School by lane 6 mile Khanapara Gauhati 22, white notary registration number 02/2013 dated 10/10/2013, and at the time of execution of this deed of agreement, say Chandra Mohan Jha also given the sale deed by deed number 19302012 dated 5/3/2012, wherein Chandra Mohan Jha purchased the said land from the Bhupendra Sundari. This we have already stated to the police, and that because they are denying at that particular suit land at the particular time, Chandra Mohan Jha was not there, but he himself has given the original deed. They were not able to produce before a trial because they have already given the original sale deed to us.
Hmm.
We have mentioned it in the FIR. Here. So if I come for the thing is that in IA 2813 actually,
Hmm.
the
Okay, then you produce the same before the court. We'll see.
yes,
Original copy. Is it with you?
my client says so. Client says so, and because and his FIR also says so. The FIR also, it has been, they have never argued on this point. They have never counterclaimed how did this went to you, because the sale deed which has come into the picture for them in 2019 post right now, it was already mentioned in 2014 by Assam. It is mentioned in the FIR.
Hmm.
So since it is with us, they were not able to produce it before the line.
Okay.
This is what we have to say in the IA 2813 of 2001.
You produce it before the court. We will issue direction to you.
Yeah. If and if my lord,
And he has made my case more simpler because in the plaint he has never said so that they are in possession of the original, and that is the reason, my lord, we could not produce it. Now he is, my lord, himself made it much more easier for me to rely upon that additional document without the, my lord, to go through the rigors of law. If the original is with them, that means it is an admitted document, and if they admit, nothing more need to be done. Allow us also to file that certified copy.
certified copy, we also can go and the court should allow.
I am saying a law.
Whoever has the original copy.
Yes.
Certified copy, I also can go, I can get it 10 times. What's the big deal in it? Original has to be.
No. The question is regarding admissibility of the certified copy.
Yeah.
It can be admitted.
Yes.
It can be admitted under section 74, subsection 2.
Here it has, we had mentioned it before the police, they have got, they have
Okay,
gone
okay.
through this. They
Let
have-
them do it within a
Mr. Singh.
time-bound manner, Malo.
Pardon?
Within a time-bound manner, they should furnish it with the court registry, Malo, with the registrar of this honorable court. The original directions may be given to them to produce the original, and we may be also given the liberty to place on record the certified copy.
Okay. Heard, Mr. A. Singh, learned counsel for the applicant in IS civil number 2812 of 2019. And Mr. I.S. Majumdar, learned counsel for the respondent opposite party. This application under Order 41, Rule 27 of the Code of Civil Procedure is preferred by the applicant. The appellant Chandra Mohan Jha in RFA number 73 of 2019 under Order 41, Rule 27 of the Code of Civil Procedure to file additional evidence on record. Mr. Singh, learned counsel for the applicant, referring to the deed of sale between the applicant and one Upendo Sodhuri, which is enclosed as Annexure 1 at page number 7 of the application, submits that the said deed of sale could not be produced before the learned trial court during trial, and that during the course of hearing before this court, when the question was put in respect of the aforesaid sale deed, then this application under Order 41 Rule 27 has been filed for allowing to adduce additional evidence. But it appears from the Annexure 1 that the said copy is a certified to be true copy. And when a question was put to Mr. Singh, learned counsel for the applicant, he submits that he has to inquire from his from the applicant as to whether the original copy is available with him, as because in connection with one case at Shillong, all the original documents have been seized. However, he will be able to produce the certified copy of the sale deed, deed of sale, and also the permission. Now, also the no objection certificate issued by the GMD, Gauhati Metropolitan Development Authority, to the applicant. And he prays for granting him some time to produce the certified copy of the aforementioned document or the original copy of the said documents. However, Mr. Majumdar, learned counsel for the opposite party, respondent, submits that the original copy of the deed of sale, Annexure 1 of the application, is with the respondent opposite party herein, and the same has been mentioned in the FIR lodged by the respondent herein with the officer in charge of which police station?
Police station.
Deshpur police station.
On
Deshpur
15
police
May
station.
2024.
On
15 May 2014.
and he will be able to produce the original sale deed before this court. In view of above, it is provided that Mr. Majumdar shall furnish the original copy of the deed of sale dated 5th of March 2012 before the registry of this court. On or before
2 weeks.
They are here, my lord, and they are here only in case within a week time, my lord, because the vacation will commence. Let it be before the vacation.
2 weeks, I don't think the vacation will start. 2 weeks will how much? 10 days. Huh?
Vacation start from
27th.
26th.
26th.
So we can have a hearing because first of all, he has to.
25th.
no, Mr. Majumdar, you say after 15 this court will not be sitting here
Yes.
for 2 weeks
15 might not.
before 15.
Before 15th. Okay, yeah.
Okay.
15th will do. 15th.
No, not 15.
No, non-inclusive of 15.
14 is Sunday. 12.
12th is all right.
Today is our 4th. Okay.
12.
12th is all right. Malad. That is a Friday.
12. In respect of
Doctor,
the
can I
RFA
have it?
number 73.
On one day, alia, I have a.
11th.
11. Okay, 11.
11.
11. In respect of RFA number 73, argument of the appellant, Mr. A. Singh, is concluded. Anything remain to argue?
Oh, Malad, because we have to still argue, Malad, I'm the defendant in his appeal. That is the main appeal. First of all, we have to establish my right. I'm only trying to establish my right only so far. The judgments again, Malad, in his matter, I have to still cite. Malad, his case is entirely different.
No. In your case, your
Yes, I
argument
have
is
concluded, my
completed.
lord. Only with respect to this document, my lord.
Yes.
That is all.
Okay.
So another 15 minutes maybe maximum can be given to me. 10 minutes.
10 minutes.
Yes.
Okay. You complete your argument then.
Grateful. So very grateful.
No. You have to ask him. The court has asked him to continue with the
Yes,
argument.
let him complete
Yeah, that's what.
argument in his appeal.
Yes, Your Honor.
Mal, I'll tell my lord, the only thing I want to buttress my argument is that if this IA is allowed, or because this IA is for production of a particular document only, and my lords found that this is only a typed version and can't be looked upon now. So once that original is brought by him, then I don't need to go through the rigors of that matter, because in case my learner friend, my lords may only ask him in case he's wanting to contest this application, because it is for production of an additional document, additional evidence. And if he's not objecting to it, that evidence can be, my lord, taken into consideration while deciding the appeal. So he has to only, my lord, first of all say that he's not objecting to this IA, and they have got the original. Then I don't need to argue any further.
No. While he agreed to produce the original document before the court, then definitely he agreed with the prayer being made in this
Yes.
IA.
Then my only argument left out is that what is the ultimate relief I want to pray for? But I'm only wanting a limited ground, which I have started off, that the trial court's direction that I am not entitled in para 21, that I am not entitled for any kind of relief qua my counterclaim in issue number 10 at page para 21 has to be set aside for non-production of this exhibit which we want to produce now before my lords. And that is the only point, my lord. I was trying to pitch high my arguments that if this document is now taken on record and considered in evidence, then my right over the property gets established. And if that gets established, my lord, the judgment in my matter can, my lord, flow from that I am actually entitled, as I'm the owner of this property. So I am only wanting a decree or a declaratory relief from now before this honorable court to set aside the limited finding of the trial court disentitling me from my right over the property as owner on account that I have failed to produce and prove this document. Because if original is there and he is admitting that it is my property, then I don't need to argue any further. Then the provision itself is very much clear. Section 58.
All right.
That is all.
So Mr. Mazumdar will hear you. on
But
next
as
day.
regards the appointment of a receiver, my lord, that may be kept pending. My lords may only put to them that they want to file a response or not to file a response.
Yes.
11, this new one, no?
Yes.
New one.
No, you say we can finally hear and dispose of the entire matter.
Entire matter. So there is.
My lord, may ultimately, my lord, the relief which I am wanting ultimately is, supposing my lord are first to establish my right, supposing the sake of argument, the trial court has not dealt with anything with the possessory rights of mine, my lord. If my lords are to agree with me on account that I have become the owner, then again, my lord, we have to go and file an execution. Because what is happening here is, for the last 13 years, my lord, he is sitting over the property without any, my lord, recourse of mine to recover it.
Okay, let us first complete the argument.
Yes, very well.
Later on, we
So
will
that's why
proceed
I'm
on the
saying
same.
keep it pending, and my lords may put to them whether they want to file a response or they will want to argue it finally without filing a response.
Yes, Mr.
We will argue at the time.
Great.
Entertainment. Okay,
After.
okay. Argument of Mrs. Singh, learned counsel for the appellant in RFA number
73.
73 of 2019 is completed. Hearing of argument of Mr. Majumdar, learned counsel for the respondent stands adjourned, as he is directed to produce the original copy of the deed of sale dated so and so before this court. Accordingly, it is provided that SSL list this RFA 73 2019 and RFA 111 of 2019 and IA number 2813 and 2812 of 2019 on
11th.
11.
Under parted category.
RSS will keep the
I'm so
numbers
grateful.
parted.
But if the board is heavy on that day, my lords may permit right now to allow us to make a
Okay,
mention.
on the RSS list the matter as top of the list item.
I am so very grateful.
Item fixed at 2 p.m. Item 33.
Meet, please, your honor. Lordship, the impugn order is in page number 8. For a better understanding, may I read your lordship?
Page number
8, your lord, of the memo packet.
yes.
The claim case arose out of petition preferred under section 166 of the Motor Vehicle Act 1988, filed by the claimant claiming compensation from the opposite parties on account of injury sustained by her in a motor vehicle accident occurred on 21/4/2008. The averments contained in the claim petitions are extracted below. On 21/4/2008, at about 4:30 a.m., while the claimant was proceeding towards Langtisinga from Gauhati by the vehicle bearing registration number so and so, and when she reached Nayagaon on 31 National Highway, suddenly the said vehicle, due to driver's rash and negligent driving, knocked a truck bearing registration number so and so from behind, which was parked on the road at Nayagaon near Shiv Mandir, as a result of which the claimant sustained injuries on head, hands, legs, chest, and other parts of the body.
Mr. Dutta,
Yes, Lord.
you are not required to read the entire judgment. You come to the grounds for appeal.
Okay, Your Worship. Only the relevant portion I will read.
Hmm.
The portion which we are challenging.
Hmm.
That is the disability certificate, Your Lordship.
Certificate was exhibited before the
Yes,
court,
Your Lordship.
before the tribunal.
Yes, Your Lordship.
Is it part of the record?
Yes, Your Lordship. Exhibit 226.
Okay.
Your Lordship, I will only read the relevant paragraph in the impugn order.
Which is the relevant paragraph?
Your Lordship, it would be Page number 19, paragraph number 21.
21.
Yes, Lord.
Exhibit number?
226. It is in page number 779.
7,
But your lordship, before that, I may read the paragraph number 21.
Hmm.
PW, may I read your lordship?
Yes, yes.
PW2 in her evidence stated that after the accident, the injured was treated at Lower Assam Hospital, Bongaigaon,
Mm.
wherefrom she was shifted to JNRC Hospital, Gauhati. Exhibit 199, the discharge certificate of JNRC Hospital reflects that the injured was admitted in Lower Assam Hospital, Bongaigaon on 21/4/2008 and was discharged on 27/4/2008. On careful perusal of the vouchers and bills by the claimant, it reveals that an amount of rupees 9,44,243, say rupees 9,44,500 was expended during treatment of the injured. As such, the claimant is entitled to this amount as medical expenses for the injury sustained by her. The claimant's mother, PW2, in her evidence stated that due to the accident, the claimant became 90% permanently disabled. Regarding disability, claimant examined PW3, Dr. Shamik Chaudhary, one of the member of medical board, who deposed that on 29/8/2013, he examined Soma Kundu and issued the disability certificate exhibit number 226, and they assessed her disability as 90%, which is not curable and permanent in nature. He also stated that her disability was post-traumatic quadriparesis and she cannot move without wheelchair. He proved his identity card as exhibit 228. Claimant also examined PW4 Mridul Kanti Anjoy, the employee of Social Welfare Office, Kuch Bihar, who deposed that as per doctor's report, the district social welfare officer used to issue identity card of disabled person. He stated that medical board assessed the disability of Soma Kundu as 90%. He proved the identity card issued in favor of Soma Kundu as Exhibit 226. During cross, he admitted that there is no mention in Exhibit 226 as to how the disability was caused to the claimant. As per evidence of PW4, Mridul Gandhi Anjoy, also the claimant has 90% disability. Exhibit 226 shows that the claimant cannot walk without assistance of escort. The discharge summary reflects that she sustained traumatic brain injury, sequel, bilateral equinus deformity. She cannot move without wheelchair and not yet in a position to give deposition. Considering the injury sustained by her, this court considered her disability as 90%. And as such, the claimant is entitled to pecuniary damages for the loss of earning capacity to the extent of 90% due to injury sustained in the accident besides medical expenses. Now, taking to the question of income, claimant stated that she was working as female attendant at Sharma Pathology, from March 2007 till the date of accident, and she was drawing an amount rupees 5,000 per month as salary. Regarding income, the claimant examined PW3 Ratan Sharma, the owner of Sharma Pathology, who deposed that Soma Kundu was working as female attendant in his pathology from March 2007 till 15 April 2008. He further stated that on 15 April 2008, she availed leave and thereafter she could not join in his laboratory as she met with an accident, as a result of which she became handicapped and hence he has to discharge her from job. He stated that at the beginning he paid an amount of rupees 5,000 per month. He proved the income certificate as Exhibit 5. So her monthly income is accepted as rupees 5,000. As per identity card, Exhibit 226, she was 24 years old at the time of examination. Such for the age group of 21 to 25 years, multiplier 18 would be applied. Having regard to her age, 30% of future prospect should have been added to the monthly income that could be fixed for determination of loss of earning, as she had lost her earning being permanently disabled. Therefore, with addition of 30% towards future prospect, her monthly income would be rupees 6,500. Hence, till loss of income due to disability comes to rupees 12,63,600. Apart from that, in this case, the claimant is reduced to such a state that she is unable to do any work, manual or otherwise, without subjecting herself to pain and suffering again and discomfort. In an accident, if a man is disabled for a work which he was doing before the accident, that he has no talent, skill, experience, or training for anything else, and he is unable to find any work, manual or clerical. Such a man, for all practical purposes, has lost all earning capacity. He possessed before, and he is required to be compensated on the basis of total loss. Admittedly, at the time of accident, the injured was a young woman of 24 years. For the remaining life, she will suffer the trauma of not being able to do her normal work. She was in hospital from 22/4/2008 till 15/6/2008. Therefore, I feel that the ends of justice will be met by awarding her a sum of rupees 3 lakhs in lieu of pain and suffering and trauma due to loss of ability to move herself without help of others. Now point to the consider whether the claimant is entitled to get any other amount or not. From the record, it appears that the claimant has lost her ability to move herself without help of others due to the injury sustained in the accident, and at that time the injured was in the age of 24. The claimant is expected to live for at least next 50 years. It can only be a matter of imagination as to how the injured will have to live for the rest of her life with the help of others. Due to her disability, as discussed above, she cannot live like a normal human being and will not be able to enjoy life. The prospects of her marriage have considerably reduced due to loss of her moving ability without wheelchair. She will suffer lots of difficulties. Hence, it would be just and reasonable to award her a sum of rupees 2 lakh for the loss of amenities and another rupees 2 lakh towards enjoyment of life and marriage prospect. Further, she is required to periodically to periodical checkup and has to purchase wheelchair periodically. Hence, an amount of 50,000 is awarded as future expenses. Now on the computation. Now, your lordship, I'll take your lordship.
So, regarding this amount, medical expenditure,
Yes, your lordship.
you are not disputing it
No, your
because
lordship.
it is based upon the vouchers produced by
Yes,
the
your
produced
lordship.
and exhibited
Yes,
at the
your
time of trial.
Yes,
So there is no dispute about it.
no dispute regarding
So dispute regarding this income, loss of income,
loss of income, but the disability we are accepting.
disability
She has-
accepting.
Yes, only to certain extent, your lordship, that she has suffered the disability
Mm.
of 90% as per the disability certificate.
Mm.
But in that disability certificate, it is not clear that whether she has suffered permanent total disability or partial total permanent partial
What is the
disability.
finding of the tribunal on this point?
This was the finding, your lordship, in paragraph number 21.
But whether you have raised any objection before the tribunal at the time of hearing?
Yes, your lordship.
Hmm?
In paragraph 21, it is there. We have cross-examined the PW3, which is the medical officer.
Hmm. Whether you have been
It
able
is in the report, your
to
lordship.
discredit that witness?
Your lordship, it will be better if your lordship peruse that
You will.
examination. It is in page number 13, deposition of PW3, the medical officer.
Page number?
Page number 13. দুটা আছে আৰু এটা তলত আছে। সেইটো ধৰক 13 13
Copy number 1.
I think in the second copy it is there. Copy number 3.
Copy number 3. PW3 Dr. Somik Chaudhary.
Yes, your lordship.
No, only two cross-examination, two part of cross-examination, one by OP number 1 and one by OP number 4.
Lordship, PW3 is also there
Where?
in page number 13. I believe it should be there.
Page number?
13.
No, 13. 13 is the chief, examination in chief.
PW3.
After chief, your lordship, cross-examinations. May I read the oath part?
Yes.
I appeared in this tribunal on receipt of summons from this tribunal. On 29/8/13, I was
No,
working in.
you come to the cross part.
Yes, your lordship. Your lordship, the examination is also important because
Mm.
he's deposing
Mm.
what was the issue with the claimant.
Mm.
On from the second line, I'm reading it right.
Mm.
On 29/8/13, I
Mm.
was working in the hospital, so and so, as orthopedic. That is ineligible.
Mm.
Ineligible, your lordship. I cannot. On that day, I examined Soma Kundu, daughter of Ania Kundu, and
Issued disability
issued-
certificate.
Yes, your lordship. And
Exhibit
issued disability
226.
certificate exhibit 226 in favor of Soma Kundu, and exhibit 226 is my signature.
Mm.
I issued the certificate through medical
Medical board.
board. I am
I am one member.
one member of
of the
the
medical board.
medical board. We assessed the disability of Soma Gundu as 90%, which is not curable. The said disability is permanent in nature. The disability was post-traumatic quadriparesis and she cannot move without wheelchair. Exhibit 228 is my identity and the
So
signature.
your answer is there.
Yes, now to the cross-examination part. Lord.
Your answer is there. It is categorically stated that which is not curable.
Yes, Your Lordship. But the
And the said disability is permanent in nature.
yes, Your Lordship.
Hmm.
I'll also rely on some judgment where it says that the permanent disability suffered by the claimant
Hmm.
is not equal to the loss of future earnings.
Hmm.
If in this case, like the claimant has suffered 90%
Hmm.
permanent disability, that
Mm.
doesn't mean that she has also suffered future loss of future earnings for 90%.
Hmm.
So I will rely on some decision. Now to the cross-examination part. Your Lordship. May I read? Now on 29/8/2013.
No, you are OP number 1 or OP number 4?
Your Lordship, I believe OP number 1,
1.
Oriental Insurance.
Okay.
Now on 29/8
Mm.
2013, I examined the patient.
Hmm.
I have not treated her. That is important, Your Lordship. He is admitting he has not treated the claimant
No, he was a member of the board.
board, but he did not treat her. At the midst of the treatment, he has examined her.
Yes.
He's
What
not
wrong with
aware
that?
of all the.
The board has
possibilities.
examined and given the certificate, and he signed the
Yes.
certificate, issued the certificate. What wrong with him?
Only that fact, Your Lordship. I'm saying that he did not treat her.
No, is it necessary that every member of the board has to treat the victim?
Not.
Where is the requirement?
Not strictly necessary.
Then board has assessed.
Okay.
He is member of the board. And thereafter he issued the certificate.
May I continue, Your Lordship?
Yes.
Reading the. At the time of issuance of disability certificate, the hospital maintained a register. Today, I have not produced the said register. I'm not. Your Lordship, that is very ineligible.
Mm.
May I skip it?
Mm.
I cannot say whether the disability was caused due to the accident or not.
Mm.
And in exhibit 226, I have not mentioned that the disability is not curable or there is no there is
Mm.
illegible.
Mm.
Now, Your Lordship, may I place a decision before Your Lordship?
You don't know.
There is no.
Yes, which decision you are relying upon?
Rajkumar versus Ajay Kumar.
Yes, that was the decision relied upon by the tribunal.
Yes, Your Lordship. But the procedure was not followed. Here, the procedure prescribed is given in this decision. That whether when a claimant suffers a certain percentage of disability, then how the tribunals should assess the loss of future earnings. So may I place it before Your Lordship? Your Lordship, I will read from paragraph number 9.
Yes.
The percentage of permanent disability is expressed by the doctors with reference to the whole body or more often than not with reference to a particular limb when a disability certificate states that the injured has suffered permanent disability to an extent of 45% of the left lower limb. It is not the same as 45% permanent disability with reference to the whole body. The extent of disability of a limb or part of the body expressed in terms of a percentage of the total functions of that limb obviously cannot be assumed to be the extent of disability of the whole body. If there is 60% permanent disability of the right hand and 80% permanent disability of left leg, it does not mean that the extent of permanent disability with reference to the whole body is 140%. That is 80% plus 60%. If if different parts of the body have suffered different percentages of disabilities, the sum total thereof expressed in terms of the permanent disability with reference to the whole body cannot obviously exceed 100%. The claimant suffers a permanent disability as a result of injuries. The assessment of compensation under the head of loss of future earnings would depend upon the effect and impact of such permanent disability on his earning capacity. The tribunal should not mechanically apply the percentage of permanent disability as the percentage of economic loss or loss of earning capacity. In most of the cases, the percentage of economic loss, that is the percentage of loss of earning capacity arising from a permanent disability, will be different from the percentage of permanent disability. Some tribunals wrongly assume that in all cases, a particular extent of permanent disability would result in a corresponding loss of earning capacity. And consequently, if the evidence produced show 45% as the permanent disability, will hold that there is 45% loss of future earning capacity. In most of the cases, equating the extent percentage of loss of earning capacity to the extent percentage of permanent disability will result in award of either too low or too high a compensation. What requires to be assessed by the tribunal is the effect of permanent disability on the earning capacity of the injured. And after assessing the loss of earning capacity in terms of a percentage of the income, it has to be quantified in terms of money to arrive at the future loss of earnings by applying the standard multiplier method used to determine loss of dependency. We may, however, note that in some cases on appreciation of evidence and assessment, the tribunal may find that the percentage of loss of earning capacity as a result of the permanent disability is approximately the same as the percentage of permanent disability, in which case, of course, the tribunal will adopt the said percentage for determination of compensation. Therefore, the tribunal has to first decide whether there is any permanent disability, and if so, the extent of such permanent disability. This means that the tribunal should consider and decide with reference to the evidence. Number one, whether the disablement is permanent or temporary. Number two, if the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. Number three, if the disablement percentage is expressed with reference to any specific limb, then the effect of such disablement of the limb on the functioning of the entire body, that is the permanent disability suffered by the person. If the tribunal concludes that there is no permanent disability, then there is no question of proceeding further and determining the loss of future earning capacity. But in the tribunal concludes that if the tribunal concludes that there is permanent disability, then it will proceed to ascertain its extent. after the tribunal ascertains the actual extent of permanent disability of the claimant based on the medical evidence, it has to determine whether such permanent disability has affected or will affect his earning capacity. Ascertainment of the effect of the permanent disability on the actual earning capacity involves three steps. The tribunal has to first ascertain what activities the claimant could carry on in spite of the permanent disability and what he could not do as a result of the permanent disability. This is also relevant for awarding compensation under the head of loss of amenities of life. The second step is to ascertain his avocation, profession, and nature of work before the accident. As
Okay, Mr. Dutta,
yes, Lord.
you see in paragraph number 12,
Yes, Lord.
it has been mentioned how it has to be assessed. Number one, whether disablement is permanent or temporary.
Yes, Lord.
So the this PW3 deposed that it is permanent.
Yes,
It is not curable.
yes, Lord.
Then if the disablement is permanent, whether it is permanent total disablement or permanent partial disablement. So what he has stated before the tribunal, the doctor?
Your Lordship, he did not specify
Hmm?
that it is regarding a particular limb or limbs or the whole body. He just said that she has suffered
No,
90%
he
permanent
stated
disability.
that she cannot even walk without the help of others.
Yes, Your Lordship.
Then
But he did not
she was
specify.
she was working in a laboratory.
Yes,
After the accident, she could not attend the laboratory. She has been discharged.
yes.
So,
This much we admit, Your Lordship.
hmm.
But does that mean she will be precluded from doing other stuff like tax job?
Hmm.
So in that case, 90% loss of future earnings, that will be wrong presumption.
No, even she could not move without the help of other person.
Yes, Your Lordship, but she can do a desk job or some other job which doesn't require
Whether
physical
you put
involvement.
such a question to the doctor
No, Your Lordship.
during cross-examination,
No, Your Lordship.
whether you
Those
put such a
questions were
question
not-
to the victim during cross-examination,
No, the victim was not examined.
not examined.
She was examined, but her examination was not considered because she could not be cross-examined due to some physical difficulties on her
Physical
part.
difficulties.
Yes,
If she could not depose before the court,
yes, Lord.
could not adduce evidence before the court, what kind of profession she could enter into?
On her behalf, her mother examined.
Hmm. Hmm. Whether you put any such question to her mother?
No, Your Lordship.
No. Then where is your case? Hmm?
Your Lordship, kindly adjourn the matter. Let me
No, no,
discuss
no,
with
we'll
my
not
senior
adjourn the matter.
regarding-
Since when this matter is pending? Hmm?
Since 2017, Your Lordship.
17,
Yes, Lordship.
2017. Why should we adjourn the matter? You
Because
complete your
this
argument.
question, I was not anticipating this question, that we did not
No,
put this question before the
you
tribunal.
must ready to answer any question put by the court.
Yes, Your Lordship.
You complete your argument.
Accommodation.
And whether you put such question to the mother of the victim or to the doctor, it is a matter of record.
Yes, sir.
Yes, complete your argument. So your primary contention is that the procedure prescribed by the Supreme Court in this decision has not
Yes.
been followed by the tribunal
Yes, Your Lordship.
while assessing the loss of income.
Loss of income. And Your Lordship, another ground,
Hmm.
kindly come to page number 15 of the Rajkumar versus Ajay Kumar decision.
Page number 15.
15, Your Lordship.
15 or
Very-
paragraph number 15?
15, yes, paragraph number 15, Your Lordship.
Okay.
It may be noted that when compensation is awarded by treating the loss of future earning capacity as 100% or even anything more than 50%, the need to award compensation separately under the head of loss of amenities or loss of expectation may disappear. And as a result, only a token or nominal amount may have to be awarded under the head of loss of amenities or loss of expectation of life, as otherwise there may be a duplication in the award of compensation.
Yes, you tell me who will marry her?
No, the marriage prospect I'm not saying, Your Lordship.
Then
Only the loss of
what is the
amenities,
expectation of life then?
Your Lordship, only upon that head, those
Hmm.
heads. I'm saying that a nominal amount ought to have been
Nominal
given.
amount.
Yes, Your Lordship, but here 2 lakhs per
Hmm.
2 lakhs were awarded on
Hmm.
each head.
So according to you, this rupees 2 lakhs is excessive.
Yes, Your Lordship.
Okay. Then any other point?
Yes, Your Lordship. Kindly come to page number 22, Your Lordship. Under the head of pain and sufferings and mental agony, 3 lakhs was awarded.
Hmm.
Now I want to place, place before Your Lordship another decision.
Hmm.
That is the AM Ahmadi versus pest control, MS pest control.
Hmm.
Lordship, kindly come to the last page of the decision,
Hmm.
paragraph number 17.
Yes.
The claim under S1 number 16 for pain and suffering and for loss of amenities of life under S1 number 17 are claims for non-pecuniary loss. The appellant has claimed lump sum amount of rupees 3 lakh each under the two heads. The High Court has allowed rupees 1 lakh against the claims of rupees 6 lakh. When compensation is to be awarded for pain and suffering and loss of amenity of life, the special circumstances of the claimant have to be taken into account, including his age, the unusual deprivation he has suffered, the effect thereof on his future life. The amount of compensation for non-pecuniary loss is not easy to determine, but the award must reflect that different circumstances have been taken into consideration. According to us, as the appellant was an advocate having good practice in different courts, and as because of the accident he has been crippled and can move only on wheelchair, the High Court should have allowed an amount of rupees 1,50,000 in respect of claim for pain and suffering and rupees 1,50,000 in respect of loss of amenities of life. We direct payment of rupees 3 lakh rupees against the claim of rupees 6 lakh under the heads of pain and suffering and loss of amenities of life. Your Lordship, here 1,50,000 was given in
Hmm.
regard to pain and suffering,
Hmm.
and under the head of loss of amenities 1,50,000 was given.
Hmm. You see, this decision was of 30 years back.
Yes, Lord.
What was the value of money at during that point of time and as of now?
Because of inflation now
Mm.
the
Mm.
value of money has deteriorated.
Yes.
Okay, Your Lordship, it's up to Your Lordship.
Hmm. Any other point?
No other point.
No other point.
That's
Okay. Mr. Goswami, you are for?
With no liability on me.
Oh, you have no liability.
Uninsured.
Okay. 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 Yes. Where is Mr. Khan? Court number 7. Court number 7. So he cannot come today. Hmm? Okay, take them. Heard Mr. S. Dotto, learned counsel for the appellant. Mr. Goswami for the respondent, and also Mr. R. Ahmed, learned counsel appearing on behalf of Mr. Khan. Learned counsel for the respondent number? Yes. No, you are for. Then you are for respondent number? 1. Respondent number 1. Argument of Mr. Dotto, learned counsel for the appellant completed. Mr. Goswami submits that he has no liability. No liability is trusted upon the respondent number 4 by the learned tribunal. And Mr. So-and-so submits that conducting counsel Mr. Khan is on legs in court number 7. And as such, he plays for adjourning the matter to some other date. Where allowed, recessal list the matter as part heard on 11. 11.
also.
Will it be section number 17?
Right. Yes.
In this case, what's it, vehicle involved in the accident was a goods vehicle, Lordship.
Was
Vehicle involved in the accident was a goods vehicle. It was
Goods
a mini
vehicle.
truck. It was a mini truck. And this is was traveling as a passenger in the vehicle. And the vehicle met it with an accident and he died
as a passenger.
as a passenger. Also. As per our contention, he was a gratuitous passenger of a goods vehicle, and the policy, insurance policy does not cover the risks of a gratuitous passenger. Accordingly, the legal heir of the deceased is not entitled to get any compensation.
How the tribunal has dealt with that issue?
Tribunal came to conclusion that he was the owner of the goods. Let's say.
Pardon?
He was the owner of the goods.
Owner of the goods.
Yes.
10, my
Yes.
lord. There are 17, my lord.
May I read the judgment also?
Yes, come to the relevant points.
My lord, page, para 17, my lord.
Yes.
Failed to adduce any evidence, my lord.
Pardon?
My lord, it has been held that they failed to adduce any evidence in that regard, my lord. That the this is was gratuitous passenger, my lord. And
They
accordingly,
have
my
not
lord,
adduced any evidence.
my lord.
What's it?
And burden is upon the insurance company. Please, my lord, let him complete it.
Yes.
What's it? We adduce evidence. What's it? We adduce evidence, and he failed to discharge his duty because no seizure list was exhibited before the court to prove that police when they seized the vehicle, there was found any goods. There was no seizure list before the court, before the tribunal. Also, kindly see our evidence, Lordship. Lordship, in the lower court record, Lordship will find in the page number 28. We examine one of our officer, Lordship, Sri Kulnan Sen Gupta. He is the administrative officer, Lordship. I
He is
see
the?
page number 28 of lower court record.
Yes.
I see so-and-so is about 32 years, son of so-and-so, presently working as a assistant manager claim HDFC Agro General Insurance Company, so-and-so, solely FIR and orders under. That I have been serving as assistant manager claim HDFC Agro General Insurance Company Limited since 2015. This is true and correct. That we have taken a stand in paragraph 3 of our written statement that our company shall be liable to pay compensation only subject to compliance of terms and conditions of the policy. From the bare period of the claim petition, it is clear that the deceased was traveling in the vehicle number AS01DD414115 as a passenger along with C. Gautam Bora. There is no proof of the deceased traveling with any goods in the vehicle, whereas the facts remain that the vehicle was a goods carrying vehicle. The claimant in paragraph 10 of the claim petition has stated that her husband was a passenger. That I say our company is not liable to pay any compensation to the claimant because the owner of the vehicle has violated the policy as per policy number so and so. The seating capacity in the said vehicle is only 1. I tender in evidence the said policy and mark in exhibit 1, which is issued in the name of Muhammad Ziaur Rahman. So this is our evidence, Lordship. And Lordship, and there in their evidence also, the PW1 in her cross examination, Lordship kindly Lordship will find in the page number 24 in the LCR, Lordship. I have studied up to class 10. My husband had done matriculation. I have not submitted any age proof of my husband, which my husband one
No,
Gautam Bora has.
Mr.
Page number 24, Lordship.
Mr. Bhatt. It is your plea that he was a passenger, gratuitous passenger in the goods carrying vehicle.
Lordship.
So burden is upon you. You have to establish that he was a gratuitous passenger.
Yes, Lordship. When they fail to discharge their duty, that the
No.
he
The law of evidence. Burden lies upon whom?
because no seizure list was exhibited before the court, Lordship. That the vehicle was loaded with the goods.
Maybe.
And they have also admitted that I have not submitted any seizure list to substantiate my claim that my husband was carrying goods in the offending vehicle. She admitted, Lordship. That my husband was carrying goods in the vehicle. I have not submitted any challan or any case memo or consignment to show purchase of goods by my husband on the date of accident and having carried in goods in the offending vehicle. You see that, Lordship? And admitted facts need not to be proved, Lordship.
Admitted facts means whether it was their contention that he was a gratuitous passenger of the goods carrying vehicle.
No.
It is your claim.
Their claim is that he was the, this was the owner of the goods. Their claim is that this was the owner of the goods, and our claim is that he was the gratuitous passenger. And in the cross examination, she admitted that she failed to prove that the vehicle was loaded with the goods because no seizure list was there. Neither any salan or any case memo was produced.
All those documents were, if any, was with the deceased person.
That's it.
All those documents, if any, were with the deceased person.
No document were produced, only that claimant exhibited lordship, accident information report, PM report, and income tax return, and income tax return. That is all. That's it. Except this document, no document were produced to prove that this was a owner of the goods of the vehicle.
PW1 Korobi Mozumdar is the wife of the,
Wife of the deceased.
she is the claimant.
Yes, she
Yes.
along with her minor daughter and mother of the deceased man.
Police case was registered? Mr. Bhatt,
Lordship,
police case was registered?
Lordship, police case was registered.
Is it part of the record?
336 of 2012, Lordship. Lordship will find in the para number 12 in the judgment.
You say the evidence of PW2 at page number 25, paragraph number 2, the
Yes.
last sentence. On 5/1/2012, he went to Guwahati for buying and bringing betel nut, betel leaf, coconut, etc.
It was their story, Lordship. It was their story, Lordship. that-
Their story.
Yeah.
Whether you have cross-examined him on that point?
Yes, yes, cross-examination was not,
Where?
Lordship. That is right.
Come to cross-examination of PW2.
I have not submitted a. I have studied up to class 10. My husband had done matriculation. I have not submitted any age proof. of
No,
my
no, 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 no. PW2. Claimant witness number 2.
PW2, yes. I have not seen the accident.
Hmm.
By that time, I reached the place of accident. There are around 3 to 4 persons
Hmm.
gathered there. When
Mm.
I reached the place of accident,
Mm.
the driver had left the place.
Mm.
Inside the cabin, the deceased and Gautam Bora were lying. Gautam Bora resides at Mission Sarila. I do not know whether Gautam Bora is a businessman or not.
Hmm.
Later on, he say that he knows the relatives of Gautam Bora. I do not know the occupation of Gautam Bora. I did not try to know about it. I am a businessman. From my experience, I can say that a Tata S vehicle is booked from Guwahati to Tezpur. A minimum of rupees 2,500 is required as fare. Though I am a businessman, I cannot say whether Salan is required to carry goods in a goods carrying vehicle. I cannot say whether any case memo is issued on purchase of goods by trader for resale. Every shop at the Shop Bazaar belongs to Tezpur Municipal Board. Every shopkeeper has allotment in his name of his shop room, and he is to pay rental to Tezpur Municipal Board. Later on, he says that the disease had no permanent shop. It was a temporary arrangement. Such a trader is to pay duty to tax to the municipal board. The Tata S vehicle was having full dala. The claimant never inquired me about the nature of accident. Color of the vehicle was white. It is not a, I have made false statement.
No, this statement that on 5/1/2012, he went to Guwahati for buying and bringing betel nut leaf and coconut, etc.
It was the statement of the PW1.
Yes. No, PW2,
PW2, CW2.
chief examination, paragraph number 2.
So it was written, sir. PW2.
So whether
No,
this
he was
CW2,
examined as an eyewitness, Lordship. He was examined as an eyewitness, Lordship.
oh,
Minmoy Mohanto, Lordship. Para number 3. That on early morning on 6/1/2012.
no, not in respect of whether he witnessed the accident or not.
When I reached
His deposition that on 5/1/2012 he went to Guwahati for buying and bringing betel leaf and coconut, etc.
Lordship, how
In
it is believable.
cross-examination,
He adduced that at the time of the looting the vehicle, he saw that he was the vehicle was loaded with the betel nut, and on the next
mm,
he was examined as eyewitness, Lordship.
no, that's
That
all
on the
right.
early morning he was on the spot of the accident.
There was no cross to that effect.
No, my question is whether you have been able to disclose him from this statement made in the paragraph number 2 in cross-examination. There is no cross-examination on this point.
Regarding para number 2, Lordship, there was no cross-examination.
Cross-examination.
But
So
regarding
then
para number
his
3,
evidence.
how the court will believe that regarding para number 2, he stated that he saw that the vehicle was loaded with the goods, Lordship. In the para number 3, he stated that I saw the accident, Lordship, in the next morning, Lordship.
Hmm.
Is
He
it possible,
reached
Lordship?
the place of occurrence only after the accident.
It is not on the same place, Lordship.
Hmm?
It is not on the same place. Where the goods were loaded and where the accident took place. It was on the not same place, Lordship.
No, no.
In the Lordship will find the, that the that this affidavit of evidence of mine has been written by advocates
All the affidavits are prepared by advocate.
according to
You have not cross-examined the witness on that point. So his evidence in affidavit
what
remain unrebutted in cross-examination. And that is sufficient to award the compensation in favor of the victim.
not a single document was exhibited before the court, Lordship. Not a single document. Whether
Why should we
any
why should we disbelieve their oral evidence?
Lordship, the PW1, we cross-examined the PW1.
Hmm.
She admitted.
No.
She admitted that she could not produce any documents to substantiate the fact that the
But oral evidence, why should we disbelieve? Is oral evidence is not to be considered by the tribunal?
but because as per his conduct, that he cannot say whether Salan is required to carry goods or not. He admitted.
May not know. She may not know.
He,
Hmm.
PW2.
Hmm.
PW2.
Hmm.
He claimed that he was a businessman.
Hmm.
That is why it was suggested that he adduced false evidence, although he denied.
Therefore, his evidence has to be overlooked. Is it your contention?
That is my submission also.
Hmm. And you have also no other evidence to demonstrate that he was a gratuitous passenger in the vehicle?
When no document was produced by them, that he was the owner of the goods. This is not the owner of the goods.
It is your contention that he was a gratuitous passenger of the vehicle.
If he's
Burden lies upon whom?
no, if he was the not owner of the goods, definitely he will be the gratuitous passenger.
Hmm. Okay. Yes, what is your submission?
And look, regarding, I have also another point, let's see. Regarding quantum also, let's see.
Hmm.
Deceased was 32 years age, let's see. And his annual income was considered 1,99,000.
Hmm.
His annual was considered 1,99,000.
On
But
what
it-
basis his monthly income was assessed?
1,99,000 as per the income tax return, let's say.
Income tax return.
That's it.
So what wrong with that finding?
Finding number, page number 12. Income tax return.
Yes.
Then let's say total income 1,99,000 at 50%. That's as per the prononcity case. The future prospect should be 40% instead of 50%. Let's say when the age of the deceased is in between 30 to 40 years.
Hmm.
When the
What was the age of the victim?
32 years old.
32 years.
That's why it should be 50 below 40.
Below 40?
It should be 50%.
no regarding salaried person. Regarding the salaried person,
Hmm.
it is 50%. If he was a self-employed or the businessman, then it is 40%. It is settled, Your Lordship.
Yes, any other point?
Since your lordship has gone through all the evidence, my lord, I will not bother with the evidence, my lord. So I'll just place the judgments on the burden of proof, my lord. One is, my lord, this Pappu and others versus Vinod Kumar Lamba, it's 2018 3 SCC 208, my lord. It's relied on the Swaran Singh judgment, my lord. I'll put it both the judgments, my lord. Flag lord. Yes, the short paragraphs are there, my lord. Where it says, my lord, when there is a defense of, my lord, violation of policy condition, my lord, burden lies on the insurance company. As your lordship has rightly pointed out, my lord. In the both the judgments, my lord, I flag mark and take the, my lord, paragraph, relevant paragraph, my lord. These are the burden of proof, my lord. Your lordship well aware of that, my lord. That I'm just putting handed over the judgment, my lord. Regarding the, my lord, future prospect, my lord, this pronounced judgment that's says, my lord, in paragraph, my lord, I'll just
I may find it.
perhaps his contention is right to that effect, my lord, since he's self-employed, my lord. So it should be 40%, my lord.
40%.
Yes, my lord.
So Mr. Bhatto is right in
Yeah, in
to
that
that extent.
respect, my lord. Right, my lord. Since it's not salaried person, my lord, it's self-employed person, my lord. So I not need to produce it, your lordship wants, my lord, I can produce the judgment, my lord.
Which one?
Pronounce it, my lord.
Not
It's not
necessarily.
necessary, my lord. My humble submission is that, my lord, we have used ample evidence to show that, my lord, he was the passenger, he was carrying the betel nuts along with him, my lord. And they could not rebut that evidence, my lord. Your lordship has seen all the evidence, my lord. And since, my lord, they have denied that, my lord, they failed to prove that, my lord, that he was not carrying goods, my lord. Only, my lord, saying that, my lord, he has not produced challans and all, my lord, that will not suffice, my lord. So in that aspect, my lord, they are liable to make the payment. And even though, my lord, that ground is taken, my lord, that, my lord, all the relevant judgment will, my lord, pay and recover principle will apply, my lord, in any case, my lord. Because I will, your lordship.
No, is there any order of pay and recovery here?
No, my lord.
No.
But since,
It
my
was
lord,
not
they have
given,
taken this
Lordship.
ground in the appeal, my lord, that's why I'm relying on that, I'll be relying on that judgment also, my lord. The very recent judgment of 2025, my lord, which relied on all other judgments, my lord, and saying that, my lord, even in case of, my lord, breach of violation of policy conditions, my lord, the pay and recover principle will apply, my lord. So that's what is the recent judgment, my lord. There are various judgments, but the judgment is of 2025, my lord. Paragraph 12 to 17, my lord. It's relied upon all other judgments and just read 2-3 paragraphs of this.
Paragraph?
12, 13, 14, 15, 16, 17, 18, my lord. Well, my lord, the next question which arises for our consideration is whether the insurance company is liable to indemnify the compensation amount to the claimant appellant and thereafter recover the same from the driver and owner of the vehicle. According to the facts in hand, from bare perusal of the report, it is found that the vehicle in question was installed with the liability only policy and no premium was paid to cover the driver, owner, or a passenger traveling therein. However, even then, in our view, courts below are in holding that insurance company is not liable to pay the compensation to the claimant appellant for principle of pay and recover or to have been invoked. As such, we think we are inclined to interpret the above findings of the courts below. We must avert to the position of this court in National Insurance Company versus so and so.
Okay, all right.
Melody. I'm not bothered reading this, the entire remaining paragraphs.
But in my humble submission, my lord, they have totally failed to discharge their burden, my lord. To show that, my lord, he was not carrying the goods, my lord.
My humble suggestion, it is a big case for the pay and recovery, lordship. Here, right will be no way affected, lordship.
Heard. Mr. K.K. Bhatt, learned counsel for the appellant, Mr. Sundar for the respondent, argument conclude. Judgment reserved.
Item 18.
My lord.
May I please your lordship, my lord, this is in respect of commencement of compensation and sustaining of the liability. In this case, my lord, the appellant, honorable tribunal sustained the liability upon the owner of the vehicle to a sum of rupees 9,94,95,000. Page 24, my lord, operative part, 9,94,500. Now, the main crux of this case is who is liable to pay the compensation to the claimant? This is the main crux. Award was given. Now, who is liable to pay the compensation? As per the judgment of this honorable tribunal, my lord, the tribunal sustained the liability upon the owner of the vehicle. The paragraph number 16. Now the question is who is liable to pay the compensation to the claimant? As per Exhibit A, computerized document issued from DTO Karbi Anglong, the driver Pankaj Sharma was authorized to drive motorcycle with gear LMB, non-transport, and which is valid till 2032, which has been exhibited by junior assistant Sunia Ingtipi of DTO office Karbi Anglong. As such, the driver was not authorized to drive Tata DI, which is a transport vehicle. When the owner of the vehicle, Tata DI, had violated the policy condition, and during the license condition is not liable to indemnify the owner of Tata DI, and owner of Binoy Prasad is liable to pay compensation to the claimant. This is the crux of this appeal, my lord.
So what wrong with this finding?
The wrong is the finding, my lord. The pay and recovered. This is the theory, my lord. This is the liability of the insurance company to pay and recover, because this is not the fault of the claimant. Your lordship is very much well aware about the pen recovery. So the other issues are there, my lord. If your lordship kindly have a look of the other issue in respect to paragraph number, my lord. Page 18, my lord. Para 5, my lord. Page 18, para 5.
Page 18.
Yes, my lord, para 5 of the judgment.
Yes.
Upon pleading of both the sides, the following issues framed for adjudication of the case. One, whether the claim petition is maintainable. After perusing the evidence, facts and evidence, learned trial court affirmed in favor of the claimant, my lord. Number two, whether accident occurred due to rash and negligent driving of the driver of the vehicle or so and so, so and so. This is also affirmed by the learned tribunal in favor of the claimant. Third, my lord, whether the claimants are entitled for compensation, if so, what relief the claimant is entitled. This is also in favor of the claimant. 9,95,000 was awarded. Now, to whom the claimant is entitled and to who will liable to pay the compensation. This is the fourth issue. While deciding the issue number 4, my lord, the learned tribunal fastened the liability upon the owner of the vehicle. There is no violation of the policy. The only is, this is the motorcycle license, motorcycle with gear LMB license, and this is commercial vehicle. That is the difficulty. That is why the claimant ought not to suffer. This is the owner. This is the owner. So
No, this appeal is preferred by whom?
appeal preferred by the claimant, my lord.
Claimant.
Yes, my lord.
Hmm.
Claimant preferred the appeal because the judgment was given in favor of the claimant,
Hmm.
awarding a sum of rupees 9,95,000, my lord.
Hmm.
And in respect of issue number 5,
Hmm.
the learned tribunal fastened the liability upon the owner of the vehicle,
Hmm.
who is liable to pay compensation.
Hmm.
My lord, your lordship is very well aware that just now one judgment has been referred by one of my our colleague, regarding pay and recovery. In Saran Singh case and other cases, your lordship, I have the judgment,
Hmm.
and your lordship is very aware the pay and recover the amount. But how this tribunal has
No,
committed?
you have no grievance in respect of the quantum.
Now I am not raising grievances about the quantum. One issue,
Your grievance
one is
is
also there.
that the liability should be fastened upon the insurance company.
Insurance company. Now I am not raising the issue in respect of the quantum.
Hmm.
Though my issue number 1 is ground 1 is about quantum, but I am not preferring this. And my only submission before your lordship, the pay and recovery, there is nothing wrong in respect of the claimants. Why the claimant should suffer?
No. Is it your case that the owner is unable to make payment of the amount?
No, that is not our issue. Our issue is, my lord, to fasten the liability, because the law is prevailed that the
No. Mr. Talukdar, you
insurer
say
is liable to pay.
in all the cases, this pay and recovery principle cannot be applied.
My lord, in pay and recover, because I have made an appeal, my lord, on the ground that the insurance company is liable to pay compensation.
It is also not your case that the owner is not in a position to make payment of the awarded amount.
That part that appellant is not taken into consideration. Only appeal has been filed with the appellant on the ground that the quantum, and second ground is, my lord, the pay and recovery.
Hmm.
My argument is very limited to the extent of pay and recovery, my lord.
No, I don't know how you were agreed for this pay and recovery.
My lord, since the vehicle is insured with the insurance company, insured with the policy is valid, my lord.
Policy is valid,
is
but
effective.
policy condition is violated.
Yes, only
Therefore,
not violated, my lord. The mere evasion is, in the true sense of the term, mere evasion, not completely violated. The driving license is motorcycle with gear, and here is commercial vehicle. That is why a claimant ought not to suffer, my lord. There are lot of judgment are there, my lord. Your lordship very much well aware that claimant ought not to suffer. That is the main crux of this case, my lord.
no.
And for this,
Mr.
But-
Talukdar, you see, on account of violation of the policy condition, the tribunal has fastened the liability upon the owner of the vehicle.
Owner of the vehicle.
So what wrong with that finding?
Well, my lord, this is the wrong, my lord, this, since the policy existing is there, since there is no lapse in the
Maybe.
policy. First,
Maybe policy is there,
policy is there.
but condition
Only-
is violated.
Here is a motorcycle, my lord, here is motorcycle,
Hmm.
here is a motorcycle with gear, LMB, and the driver of the vehicle is who has who has drive the commercial vehicle.
Hmm.
That is the part, that is the concern of the owner of the vehicle, not the claimants. So a claimant ought not to suffer, my lord.
Okay. It's whether the driving license was exhibited,
Yes, yes.
exhibit
yes,
number,
Yes, my lord, driving license was exhibited as
Exhibit A.
exhibit A. Page 55, my lord, on the
there is a decision of Supreme Court that it depends upon the weight of the vehicle. Can you find it out?
in respect of heavy motor vehicle, this weight of the vehicle is, some judgment are there, my lord, it is not with me, in respect of heavy motor vehicle.
Hmm.
Weight,
No,
part-
laden weight, it depends upon
Yes.
laden weight. Mr. Goswami, are you aware of the decision of the Supreme Court in respect of the this license, that a person having license to drive light motor vehicle, it depends upon the he can also
Drive a
he can
Transport
also drive
category.
the transport vehicle. It depends upon the weight of the vehicle.
wait, Mukund Devangan is there.
Mukund
Devangan. There's a treasures band decision.
Mukund Devangan.
Devangan.
Citation you have with you?
That's a, no, I let me find out. Mukund Devangan, you know, Mukund Devangan versus Oriental. That's the holding the MUKUND DEWA Devangan.
Yes, this judgment is with me, my lord. Yes, yes, yes.
Mukund Devangan.
Yes.
Mr. Talukdar,
My lord,
you see which part of this decision may help you? And whether the registration certificate of the vehicle is available
Weight of the Papadian looks like less than
Yes.
3,000.
less than 3,000.
yes, it is there.
Less than 3,000. Whether the registration certificate was seized. by police?
Yes, it was seized.
Seized.
Yes, my lord, seized.
Is it
Seizure
part of
memo
the
is there,
record?
my lord.
Is it on the record?
Yes, on record, my lord. Page 50, my lord, permit of DTO.
Page
Is-
number
Page 50, my lord.
50.
50.
No, that is a MBI report.
Yes.
I am asking about the license of the vehicle. There the weight is mentioned.
The Pankaj Sharma, DW1, my lord, exhibit 1, who has only given a certificate before the court as exhibit A. In the spec,
Insurance policy lordship found the weight loss in the insurance policy.
Ase.
yes.
Is it part of the record?
Probably, I can go.
My lord, in the Mukund 41, para 41 of the Mukunda judgment will cover the my case, my lord.
41.
41, my lord. Page 698. And 42 is also there.
Mr. Talukdar, you say, he was allowed to drive light motor vehicle,
Yes.
but he had driven the commercial vehicle.
Yes.
Policy is not here.
Not exhibited. But the police case was registered. Yes, Morazar PS case number 316 of 2014 under section 279 and 304 AIPC.
my lord, very recent judgment is, my lord, this is the very recent judgment.
Whose weight of the alia is 2,950. It is below 3,000, let's say.
Below 3,000.
L and B.
Below 3,000.
Is it-
Okay, we'll keep the matter as parted.
Yes.
Heard, Mr. Talukdar, learned counsel for the appellant, Mr. K.K. Bhatt, learned counsel for the respondent. List the matter as parted on 2017 matter. Hmm. Okay, after vacation. On 14th of July.
Item 19.
My lord, basically, this appeal is filed only on the grounded, my lord. The injured claimant was there as an discipline certificate we had exhibited, which is also neurological. We had examined two doctors. The doctors who has got treatment, and that doctor was also examined, and thereafter we had submitted one discipline certificate issued by the medical board. So same the member of the doctor was also examined, but that was not considered only on the ground that, my lord, that the claimant was not present. The victim, the injured person was not present in the cross examination. My lord, see the order dated 11/10/2012, page number 4 in trial court record. We had a file and petition that the victim injured was in mental disablement now, and he may not depose before the honorable court, and therefore we had filed and petition. On that petition, it was allowed, and
So
on
it
behalf of
was
the
it was an injury case.
injury case, my lord. Injury
Okay.
case and medical documents was there. Two doctors was examined. One doctor, medical doctor, was assessed that as per gazette notification in the such an cognitive disablement. So 70 to 75% will be the disability certificate.
Hmm.
But there was not mentioned any percentage. As the member of the medical board, there was no any neurological doctor. So they had advised the victim that get the some certificate assessments from the doctor who had examined you, who had treated you. So accordingly, we had get a certificate from the a neurological doctor GNRC, and they has also filed an affidavit along with the certificate, along with the assessment. And upon that, the assessments, the medical board was examined and the disability certificate was issued. And on that examination, my lord, it was clearly mentioned in the cross CW5 that the such disablement may be 70 to 75%, as the person was lost his mental balance and he was unable to work. My lord, there are another ground to file an appeal, that my lord, that the victim was an employee of a one Satyam Ispat. He was the labor and operator of the steel company, and that was also proved by the owner who issued the employment certificate. As also there was we had submitted one documents that his service was terminated. So my grounds is that, my lord, his service was terminated due to the disablement, and the doctor was examined. Doctor clearly stated in cross examination that that person is 70 to 70% of disablement. And
But the victim could not be examined by the tribunal.
yes, my lord,
That
for
is the reason.
that the reason. In the judgment also it is mentioned that disablement was not considered only on the ground that victim was not examined. For that reason, we had
The victim, if he could not be produced before the court, he could have been examined by commission.
no, my lord. See, therefore, my lord, due to his mental disability, as the person is totally lost his mental balance.
Okay.
So his wife is filed an affidavit, and she was also examined. Before that, my lord, for examination of wife, we had filed a petition. That is, the order is also mentioned in order dated 10/11/2012 in trial court, page number 4, my lord.
10/11.
2012, page number 4 or trial court record, my lord. Sorry, my lord, 11/10/2012. Sorry, my lord. 11/10/2012.
So the application was allowed
Yes, my lord.
and
Petition-
thereafter wife was examined.
Yes, my lord. Wife was examined.
Then why the evidence of the wife was not considered?
Wife was considered, my lord. Wife was considered. My contention is that, my lord, disablement certificate was not considered as in the judgment copy, my lord. Can you see the page number? Judgment. My lord, can you see the judgment copy of the trial court, page number 10? Here is mentioned that, and the exhibit number 49, certificate issued by the district medical board were exhibited. But as the claimant did not appear before the tribunal and the affidavit in evidence, no face of cross for the OP side. So the claim regarding the permanent disablement of the claimant could not be considered. The claimant, matlab, the MACT claim was filed by the victim claimant also. So there is no any grounds mentioned that this disablement certificate cannot be considered only such and such and grounds. That is also not considered only because of the victim claimant was not appeared before the court to face the cross. This is the one ground, my lord. And another ground is, my lord, that the termination of job was proved by the filing the termination of letter issued by the employer. Employer was also examined, and he says that this person was employed, 7,000 was permanent was given. That is also examined, and in the record also this is also available, my lord. So, my lord, as the claiming injured was terminated, his avocation was lost. So, as per Supreme Court judgment, my lord, Ajay, Ajay Rajkumar versus Ajay Kumar and others, my lord. That citations is also in item number 17 also discussed, my lord. So there is an one relevant person is that the under what ground if the there is an available disabled certificate, 100% loss of earning can be assessed. The only one point is that, my lord, if the avocation is lost due to the disability, then the loss of income will be ascertained as 100%. So in my case, my lord, the person was injured, had injury. For their injury, he lost his mental balance and he has also walking disturbance, and that is also proved by the CW 4 and 5. And his job was terminated. There in the termination, it is also mentioned that due to absence, the grounds of absence is of his accident. So, my lord, his avocation is lost, and as per disability certificate, he is disabled person. Avocation loss, so 100% loss of income can be assessed. So, my lord, but the trial court awarded only on the medical documents, whatever we have submitted as a medical vouchers. My lord, he is a head injury person. The pain and suffering was also only taken only 5,000, my lord. We have exhibited some transportation documents that, my lord, we are a residents of North Lakhimpur, my lord. We have to come to Gauhati GNRC because we had taken treatment from the date of accident till to the 2013, 3 years. So we had to come to from Lakhimpur to here and here to Lakhimpur. There are some, definitely there will be some transportation expenditure and also losing and fusing expenditure. We have submitted some documents in the affidavit in evidence that was not considered, my lord. So, my lord, as I was the age of 40 years old at the time of accident, I have lost my job only because of that accident. I'm now disabled person, mental disabled person. I have to look after my wife and my children. So awarding only 2 lakhs to me is very much, I feel very much injustice. So considering the documents submitted in trial court as well as before this honorable court, maybe enhance something that I can survive myself also. That's my submission, my lord.
Yes, Mr. Day. You are for the insurance company.
Madam, hearing this case, madam, the injured could have been examined on commission. That was not done. So
No, no. Another aspect is there. If he is mentally not balanced, then how can he be examined?
madam,
If the certificate is given by the neurologist that he is a mentally imbalanced person, then
neurologist was also not examined, madam. And
neurologist
the disability certificate given by the medical board, it is only on the basis of the neurology certificate report. Well, the patient was not examined by the medical board. It is on the evidence, my lord. My lord, kindly see this in the judgment, my lord, internal page 8. In cross by OP Insurance Company PW5 further stated that the doctor of the medical board intimated.
which paragraph you were reading?
My lord, judgment, my lord.
Yes.
8.
Page number
That's page number 8, my lord.
8. Issue number 2.
Second paragraph.
Okay.
In cross by OP Insurance Company PW5 further stated that the doctor of the medical board individually did not examine the injured. The certificate Exhibit 59 was issued on the basis of the certificate issued by Dr. N. Buragohai, GNRC Gauhati. Exhibit 59 does not disclose the word in permanent disablement. While issuing permanent disablement certificate, the board used to mention the percentage of disability. PW5 further stated in its cross that the certificate issued by GNRC does not disclose anything about the percentage of disablement. So how to assess? This is the problem. If he has suffered disability, well, definitely he is entitled to compensation. So let the percentage be assessed afresh.
Hmm.
My lord, medical, there is one board member, medical board, Mr. Dr. Jatindranath Mehta, who was the CW5.
Hmm.
It was exhibited, he was cross-examined.
Hmm.
May I read the his deposition? My lord?
No, let him complete.
Okay.
His part. Yes, Mr. Day.
So there is no material to assess the disability. Neither in the evidence nor material. How to assess the disability?
Hmm. No, Mr. Day,
My lord.
you come to evidence of PW5. Is the doctor.
My lord.
This second paragraph, this certificate was issued by the medical board after examination of Sri Laban Vishwakarma. The person was examined.
Yes, yeah.
But in the judgment, we find that well, he was not examined personally.
No, forget about judgment. He come to this evidence. PW5.
Evidence, my lord, sorry, my lord, I don't have the evidence.
It is not available.
CW5. Second page.
Second paragraph.
My lord. Then we come to the cross.
Hmm.
The doctor of the medical board individually did not examine the injury.
Yes. Every member of the board need not examine the.
Doctor, it says doctors of the medical board.
Yes. Individually not examine. Every member of the board is not required to examine the victim.
Then the question comes, who examined the dog and
Hmm?
who examined the injured? There is
The
nothing
board.
record, my lord. Whereas
The
this-
board, no, second paragraph of the examination in chief. This certificate was issued by the medical board after examination of Laban Vishwakarma.
my lord, it is contradictory, my lord, and then cross part, my lord, the certificate examination was issued on the basis of the certificate issued by Dr. N. Gauhati.
Hmm.
On the basis of the
Maybe it doesn't mean that they have not examined the victim.
there is no positive word also that the doctors, that the medical board examined the injured. This statement is also not there.
Hmm? No, in chief, I have read the line.
The cross part that has been here, that the certificate was issued on the basis of the certificate issued by Dr. N. Buragohai, GNRC Gauhati.
They may also rely upon that certificate.
My lord, in the exhibit number 59, disable certificate, there is also mentioned that a district medical board held on such and such examined Sri Laban Viswakarma 54.
Page number? Page number?
Is number exhibit 59, page number.
Exhibit 59.
Yes, my lord.
Here last exhibit is exhibit 30. Okay. Okay. What has any two photos? কোনো কথা নেই ভাই।
When the doctor of the medical board examined by his applicant, he again said that as the injury was not examined by me personally, as there is no reflection relating to his working difficulty in exhibit 59, I cannot say now whether there was any difficulty on his part two. The certificate issued by the GNRC does not disclose anything about the percentage of difficulty.
Private doctor cannot assess percentage.
So this exhibit is not available in the record 59.
My lord, I have seen that trial court record. There are some other exhibit is not available. Police report is not available. disable certificate termination letter is not also not available. Luckily, I had taken that copy at a trial court from the trial court.
So without those documents, can I dispose of this appeal?
My lord, then if the document certified copy is available with me, then I will see in my trial court record.
Certified copies are available with you.
Oh, yeah, maybe. my
You
lord.
produce,
Yeah, it's fine.
produce it.
Yes, fine.
Heard, Mr.
DR does.
Yeah,
DR does.
DR does learned counsel for the appellant, Mr. KK. A for the respondent number.
My respondent number 1.
Respondent number 1. You are here? Okay. Heard in part, list the matter immediately after reopening of the vacation.
A date may be fixed, my lord.
And during the course of hearing, it has been found that some of the exhibits, starting from 39 to 59, 30 to 59, are not available on the record. Accordingly, it is provided that learned counsel for the appellant shall produce the certified copy of the aforesaid exhibits on next date. List the matter on call.
16 July.
So in the rest of the matters, date may be taken from.
Lordship, item 26, Lordship. Lordship, next week, possible, Lordship. One
Next
IA is
week,
pending, Lordship.
Okay,
My lord,
Take-
item number 23 may also be fixed on 16 July. 23 item number. Okay,
take a date from him.
okay, okay. I'll advise.